Good morning. It is October 24th, 2013. It is now 9:03 a.m. This is the Board of Examiners for Land Surveyors meeting. I'd like to welcome all the guests that are in the audience today. The purpose of today's meeting will be to hold two public hearings. The first public hearing will deal with rules of conduct, and the second public hearing will deal with continuing education. I'll now turn this over to our attorney, Mr. Herndon, and he will now conduct the meeting from this point.
Morning. There's some paperwork up here on the desk. There's copies of the rulemaking notices up here if you want to have that to review. And also, if you're intending to speak, we need you to sign in over there. And if everybody has, I'll need to have that so I can call them up. Thank you. Okay, this rulemaking hearing is called to order. I guess before we really get, we have two hearings today. The first one that we're going to do is rules of professional conduct, if you have a copy of that notice. My name is Robert Herndon. I serve as attorney for the Tennessee State Board of Examiners for Land Surveyors. Would the agency representatives who are present introduce themselves for the record? I guess we'll start with Sue. Introduce yourself, please, for the record.
I'm Sue Brawley. I'm the public member of the board.
Tim Lingerfelt, member from the East Grand Division.
I'm Galen Northcutt, board member from the Middle Grand Division.
Good morning. I'm Jake Hoffman. I represent the West Grand Division.
Donna Mulder, Administrative Director of the Land Surveyors Board.
Nicole Evers, Executive Director.
It's Thursday, October 24th, 2013. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on rules the Board of Examiners for Land Surveyors is proposing to update the rules of professional conduct. The Board of Examiners for Land Surveyors is proposing these rules amendments because the Board has identified the need to update administrative practices regarding the above in order to better protect the public health, safety, and welfare. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the front of the room, and only those who have signed will be permitted to speak. The notice of the rulemaking hearing included the entire text of the proposed rules, was filed with the Secretary of State and published on its Administrative Register website on August 6, 2013. Ms. Mulder, what additional notice was given to the affected individuals or groups?
The notices were sent out by email through the state's Notify system.
The agency hears public comment on the proposed rules. I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will read the substance of the proposed rules into the record.
Mr. Herndon, may I interrupt briefly? Ms. Mulder, do you have a printed copy of the rules of conduct? They are not on our iPads.
Should be, but yeah, I have a print copy.
Everybody have a copy?
Yes, sir. Thank you, Mr. Herndon.
All right. Substance of proposed rules. Chapter 0820-04, Rules of Professional Conduct, and these are the amendments. Rule 0820-04.02, Conduct of Practice is amended by deleting the text of the rule in its entirety and substituting instead the following. So that as amended, the rule shall read, Paragraph 1. The registrant shall at all times recognize the primary obligation to protect safety, health, and welfare of the public in the performance of the registrant's professional duties. Paragraph 2. A registrant possessing knowledge of a violation of TCA Section Title 62, Chapter 18, or any rules promulgated thereunder, shall report such knowledge to the Board in writing and shall cooperate with the Board in furnishing such further information or assistance as it may require. Paragraph 3. The registrant shall respond to all inquiries and correspondence from the Board within 15 days from the day of receipt and shall timely claim undelivered correspondence from the U.S. Postal Service or other delivery service upon notice thereof. Paragraph 4. The registrant shall not assist in any way in the application for licensure of a person known by the registrant to be unqualified in respect to education, training, or experience. Rule 0820-04-.03, Service and Areas of Competence, is amended by deleting the text of the rule in its entirety and substituting instead the following. So that as amended, the rule shall read, Number 1. The registrant shall undertake to perform land surveying assignments only when qualified by education or experience in the specific technical field of professional land surveying involved. 2. The registrant may accept an assignment requiring education or experience outside of his own field of competence, but only to the extent that his services are restricted to those phases of the project in which he is qualified. All other phases of such projects should be performed by qualified associates, consultants, or employees. 3. The registrant shall not affix his signature and/or seal to any plan or document dealing with subject matter in which he lacks competence acquired through education or experience, nor to any plan or document not prepared by him or under his supervision. 4. In providing services, the registrant shall take into account all applicable laws and regulations. The registrant shall not knowingly provide services resulting in violation of such laws and regulations. 5. Incompetence. The following acts or omissions, among others, may be deemed to be incompetence for the purposes of TCA 62-18-116 and to be cause for denial, suspension, or revocation of a certificate of registration to practice land surveying. Subparagraph A. Malpractice. Incompetence includes, but is not limited to, recklessness or excessive errors or omissions in the registrant's record of professional practice. Subparagraph B. Disability. Incompetence includes, but is not limited to, mental or physical disability or addiction to alcohol or drugs as to endanger health, safety, and interest of the public by impairing skill and care in providing professional services. Rule 0820-04-.04 Public Statements is amended by deleting the text of the rule in its entirety and substituting instead the following so that it is amended. The rule shall read, 1. The registrant shall be completely objective and truthful in all professional reports, statements, or testimony. He shall include all relevant and pertinent information in such reports, statements, or testimony. 2. The registrant, when serving as an expert witness before any court, commission, or other tribunal, shall express an opinion only when it is founded upon adequate knowledge of the facts in issue, upon a background of experience and competence in the subject matter, and upon honest conviction of the accuracy and propriety of his testimony. 3. The registrant shall express a professional opinion publicly only when it is founded upon an adequate knowledge of the facts and a competent evaluation of the subject matter. Rule 0820-04-.05 Conflicts of Interest is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read, Number 1. The registrant shall conscientiously strive to avoid conflict of interest with his employer or client, but when such conflict is unavoidable, the registrant shall forthwith disclose the circumstances to his employer or client. 2. The registrant shall avoid all known conflicts of interest with his employer or client and shall promptly inform his employer or client of any business association interest or circumstances which could influence his judgment or the quality of his service. 3. The registrant shall not accept compensation, financial or otherwise, from more than one party for services on or pertaining to the same project, rendered in the same time frame, unless the circumstances are fully disclosed to and agreed to by all interested parties. 4. When engaged in public service on a project as a member, advisor, or employee of a governmental body or department, the registrant and his organization shall not perform services for any other client regarding or connected to the project. 5. The registrant shall not reveal facts, data, or information obtained in a professional capacity without the prior consent of the client or employer, except as authorized or required by law. The registrant shall not solicit or accept gratuities directly or indirectly from contractors or agents or other parties in connection with work for employers or clients. Rule 0820-04-.07 misconduct is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Number 1. The registrant shall not knowingly associate with or permit the use of his name or firm name in a business venture by any other person or firm which he knows or has reason to believe is engaging in business or professional practice of a fraudulent or dishonest nature. 2. The registrant shall not furnish limited services in such a manner as to enable unregistered persons to evade, subparagraph 1, federal, state, or local surveying and planning laws and regulations, or subparagraph B, registration requirements of TCA Title 62, Chapter 18. 3. Misconduct. The following acts, among others, may be deemed to be misconduct for the purposes of TCA 62-18-116 and to be cause for denial, suspension, or revocation of a certificate of registration to practice land surveying. Subparagraph A, conviction in a court of competent jurisdiction of any offense that reflects unfavorably on the registrant's ability to practice land surveying. Subparagraph B, revocation, suspension, or voluntary surrender of a license or certificate of registration to practice land surveying in another jurisdiction. Nothing in this paragraph should be construed as precluding the Board from deeming other acts and conduct to be misconduct. Rule 0820-04.08 seals is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Paragraph 1. The design of the registrant seal required by TCA 62-18-119 shall be as follows. Paragraph 2. The seal and signature of the registrant and the date of signing should be placed on all land surveys, reports, plats, drawings, plans, and calculations whenever presented to a client or any public agency to certify that the work thereon was done by the registrant or under the responsible charge of the registrant. Working drawings or preliminary documents are not required to have a seal and signature if the working drawing or preliminary document contains a statement in large bold letters to the effect preliminary, not for construction, recording purposes, or implementation. The size of the seal should be 2 inches in diameter in all cases and in all documentation requiring the registrant seal regardless of the size of the document. Paragraph 3. The registrant shall superimpose a signature, not a rubber stamp, and date of signature across the face and beyond the circumference of or adjacent to the seal on documents to which his seal is affixed. 4. The seal and signature should be placed in all original documents, tracing, or other reproducible documents so that the seal and signature will be reproduced when copies are made. 5. When the document contains more than one sheet, the first or title page should be sealed and signed by the registrant who is in responsible charge. 2 or more registrants may affix their signatures and seals, provided it is designated by a note under the seal the specific subject matter for which each is responsible. In addition, each sheet should be sealed and signed by the registrant or registrants responsible for that sheet. When a firm produces the work, each sheet should be sealed and signed by the registrant or registrants who are in responsible charge of that sheet, as required by TCA Section 62-18-122B. 6. The seal and signature shall be placed on work only when it was under the registrant's responsible charge. The registrant shall sign and seal only work within the registrant's areas of competence. 7. Maps, plats, surveys, or other documents will be deemed to have been prepared under the responsible charge of a registrant only when all the following conditions have been met and documented. Subparagraph A. The client requesting preparation of such maps, plats, surveys, or other documents makes the request directly to the registrant or a member or employee of the registrant's firm. Subparagraph B. The registrant supervises the preparation of the maps, plats, surveys, or other documents and has input into their preparation prior to their completion. Subparagraph C. The registrant reviews the final maps, plats, surveys, or other documents. And subparagraph D. The registrant has the authority to and does make any necessary and appropriate changes to the final maps, plats, surveys, or other documents. The registrant is responsible for meeting all of the preceding requirements, whether the work is being performed remotely or locally. 8. Any revision to a document containing the seal and signature of a registrant should be described and dated in a manner that conforms to the current industry standards. If the revisions are not done by the original registrant, the revisions must also be signed and sealed by the registrant in responsible charge of those revisions and otherwise identified in the same manner. 9. In circumstances where a registrant in responsible charge of the work is unavailable to complete the work, the successor registrant may take responsible charge by performing all professional services to, including developing maps, plats, surveys, or other documents, and any necessary and appropriate changes to the work. The non-professional services, such as drafting, need not be redone by the successor registrant, but must clearly and accurately reflect the successor registrant's work. The burden is on a successor registrant to show such compliance. The successor registrant shall have control of and responsibility for the work product and the signed and sealed originals of all documents. 10. Computer-generated seals, not signed with a digital signature, may be used on final original drawings provided a handwritten signature is placed across the seal and the date is written below the seal. Maps, plats, surveys, or other documents that are signed using a digital signature must have an electronic authentication process attached to or logically associated with the electronic document. The digital signature must be, subparagraph A, unique to the individual using it. Subparagraph B, capable of verification. Subparagraph C, under the sole control of the individual using it. Subparagraph D, linked to a document in such a manner that the digital signature is invalidated if any data in the document is changed. A digital signature that uses a process approved by the board will be presumed to meet the criteria set forth in subsections 10A through D above. Any hard copy printed from the transmitted electronic file shall bear the facsimile of the signature and seal and be a confirmation that the electronic file was not altered after the initial digital signing of the file. Alterations to the file shall cause the facsimile of the signature to be voided. Rule 0820-04-.09 Responsible charge of service is amended by deleting the text of the rule in its entirety and substituting instead the following so that it is amended. The rule shall read: Responsible charge of service. 1. Only officers and principals who are employed full-time for a minimum of 30 hours per week and who hold active Tennessee registration can be in responsible charge of a firm's practice. A registrant who renders occasional part-time or consulting services to or for a firm may not be designated as an officer or principal in responsible charge. 2. The officer or principal in responsible charge must be registered in the profession in which services are being offered. 3. An officer or principal may be in responsible charge of more than one firm only if the firms are at the same physical location. 4. Corporations, partnerships, and firms maintaining any place of business in this state for the purpose of providing or offering to provide land surveying services to the public shall have in responsible charge of such services at any and each place of business a resident registered land surveyor. 5. In the event of a change in the officer or principal in responsible charge, a firm cannot provide or offer services to the public until such time as the new officer or principal in responsible charge is identified. The next section is a new rule. New Rule 0820-04-.10 Practice Disclosure of Service is created by adding the following language so that a new rule shall read. Rule 0820-04-.10 Practice Disclosure. Paragraph A. A corporation, partnership, or firm offering services to the public may engage in the practice of surveying in this state, provided that at least one of the principals or officers of the corporation, partnership, or firm is in responsible charge of the practice and is registered as required in this chapter for surveyors, or is otherwise by this chapter authorized to practice. The same exemptions shall apply to corporations, partnerships, and firms as apply to individuals under this chapter. Paragraph B. Corporations, partnerships, or firms offering service to the public shall file with the Board on a form prescribed by the Board a listing of names and addresses of all principals and officers, as well as the principals or officers duly registered to practice surveying in this state who are in responsible charge of the practice in this state. The corporations, partnerships, or firms shall advise the Board in writing within 60 days of any change of status. Okay, this is where we're going to take comments from the public. I'm going to first read a written comment that was provided, and then I'm going to call the names of the people here on the sign-in sheet. This letter comes to us from the Tennessee Association of Professional Surveyors. And I'm just going to, this letter addresses both chapters, so I'm going to read the paragraph that specifically addresses the chapter that we're discussing now. On the subject of Board Rule 0820-04, Rules of Professional Conduct, a Board of Director member, who is also an attorney, found the language in proposed Rule 0820-04.073A and B to be somewhat troubling. The Board of Directors shares his sentiment. As written, we felt that subsection A is far too general. Any offense is open to subjective interpretation and could easily be abused in the future. Subsection B, as written, is also far too general. During the recent economic downturn, many honorable and competent land surveyors holding multi-state licensure surrendered one or many of these licenses for economic reasons. Attached, please find our recommended revisions to reflect these suggestions. We respectfully offer these suggestions in the spirit of improving and enhancing our abilities as professional land surveyors to protect and safeguard the health, safety, and welfare of the citizens of the great state of Tennessee. Respectfully submitted, Jimmy Cleveland, President. On the next page over, for the relevant rule, proposed revisions for Board Rule 0820-04, Rules of Professional Conduct. Suggested revision for Rule 0820-04.073 be revised as misconduct. The following acts, among others, may be deemed to be misconduct for the purposes of the statute and to be cause for denial, suspension, or revocation. Conviction in a court of competent jurisdiction for a felony or other crime of moral turpitude that reflects unfavorably on the registrant's ability to practice land surveying. Revocation, suspension, or voluntary surrender is a punitive action by a licensing board of a license or certificate to practice land surveying in another jurisdiction. If the board would like to address these suggestions, now is the time. Board like to address these comments? The written comments suggested changes for rule number 7, which is misconduct. The
Yes,
language. Okay.
Yes, sir. Concerning 3A, I recall, Mr. Herndon, it was with your assistance and help in this particular sentence under misconduct. The previous sentence that we currently have just simply said conviction in a court of competent jurisdiction of a felony. And now the new sentence basically opens that up to an offense that reflects unfavorably on the registrant's ability to practice land surveying. If you would you, just for the public's benefit, give us examples of things that would fall into that category? Because I can certainly understand the association's question relative to that. I'm sure that in the narrowest reading of that, it may be inferred as something as simple as a traffic violation or something of that nature. But I know that that's not the spirit in which this board discussed it at length while we were in the process of trying to determine the language that we would propose to have modified in this.
No, the proposed change definitely has a connection to the practice of surveying. It's intended to incorporate misdemeanors as well as felonies. Because some misdemeanors involve moral turpitude, which in the law is sort of loosely described as crimes of dishonesty. There's larceny and theft, and other misdemeanors as well as felonies that show a disrespect for the law, like resisting arrest or something that would reflect unfavorably upon a registrant's ability to make rational decisions. Is sort of what the intention is. There's some everyday, not everyday crimes, but common things that wouldn't be considered a reflection of somebody's ability. But surveyors are expected to have good judgment and respect for authority, and that's sort of what this is getting at. The current rule, as the chairman said, only has felony in it, but there are other offenses, and the board has no intention of utilizing this rule to incorporate anything that's not of that caliber. I think, did I describe that to the board's satisfaction?
Yes, you may even mention, I think we had at one point a discussion relative to things such as child support and things of that nature, things that a normal professional may not be involved with themselves, but someone else in the profession may be involved, and how that I guess one good way of explaining it, Rob, would be how other departments or entities within the state government where someone can be found at fault on issue that would potentially affect their licensure as a surveyor because of those things. You might speak to that also.
Delinquency in child support, failure to pay your school loans can get you suspended or revoked by this board, but it's not because of anything you've done relevant to our rules. It's just there's the agencies that handle child support and student loans statutorily use this board as the mechanism to enforce their statutes. It's not really a reflection on your practice. It's just that we don't have any choice about that. We're just directed by the legislature to suspend for 2 years, revoke for 3 years if you're delinquent in child support or your student loans. So that's not really incorporated into this. It could happen, but it would happen even without this revision. Does that help any?
Yes, sir. Thank you very much. Anybody else have any comment on A that you may want to speak to? No. We'll move to B now. As I read it, B is written verbatim for what it is in the current rule about revocation, suspension, or volunteer surrender of a license practicing in another jurisdiction. The board's intent here is a continuance of the existing rule that we currently have, and that's where an individual is disciplined and their license is revoked in another jurisdiction. We now have a system in place because we are a member of NCAAS. All the member jurisdictions report to NCAAS when someone is disciplined and when their license is suspended or revoked. And that system is in place for the simple notification of any other jurisdiction that that individual may be licensed in, whether it be an individual that resides and is licensed outside of the state of Tennessee but is also licensed in Tennessee, or vice versa. So if an individual's license is revoked in another state and they're licensed in Tennessee, then we will be made aware of that, and this board will review those circumstances and see if it affects whether or not that individual should maintain licensure in Tennessee. That's the spirit and intent of this. I certainly understand the direction from the letter relative to that, and the letter is 100% correct. In our current economic situation over the last few years, this board has seen a lot of in-state licensees turn their license back in and pursue other avenues of employment. But that's not the intent of this board. This board this board's intent is to be aware of these situations that are outside our jurisdiction and review those situations and make appropriate decisions to the benefit of the public and the other licensees within the state.
Surrender is something that this board doesn't do, because surrender is an action taken by the respondent, and when the board disciplines, the board is the one taking the action. Like the chairman said, this is sort of model language from NCAAS, but definitely the surrender that's articulated in this rule contemplates a surrender as if revoked. It would be somebody that surrendered a license to avoid disciplinary action. Of course, people give up their license if they're not practicing in that state, because the care and feeding of a license is expensive if you're not using it. And the board doesn't have any intention of treating a surrender as just saying, I'm just not going to renew, or you can have my license back. It would have to be a punitive measure from another jurisdiction.
Also, I'd like to speak just briefly to the other areas that the letter felt like that no changes were necessary. Not only was the review of this particular rule an effort to update and modernize the rule, as we're trying to do with other things, just as we did a couple of years ago with our standards of practice. We as a board found, and I think Mr. Hernan can speak to this also, that in our deliberations relative to complaints that were brought before the board, we found that we were very limited in being able to cite specific TCA in order to for justification relative to doing a civil penalty or suspension or a revocation. In other words, the current rule was greatly limited, and part of our study on this was relative to expanding that rule. And virtually all the language that you see that is different in the first about 5 or 6 sections where you indicated no change is language that has been crafted and modeled by the NCAAS. It's in their model rules and their model laws. Now, just as recent as August at the annual meeting, a few of those sections have been modified, and when we get to that in a little bit, we'll make those modifications. So the board felt like that we wanted to try to maintain a consistency with NCEES and their language, because a lot of states just simply incorporate NCEES language into their rules one-on-one. So we didn't do a blanket incorporation because there was things that didn't necessarily fit, maybe either with this particular rule or another rule or something of that nature. So we didn't want to totally reinvent the wheel, but at the same token, we wanted to expand the definitions of things that we may receive complaints on that are clearly detrimental to the public, but we would be able to firmly justify our actions if a registrant was in violation of those particular items. So that's where that came from.
All right, so is the board suggesting that we revise our proposed amendments based on any of these comments? Or are we going to leave them the way that they're proposed? Because I'm going to write a response letter memorializing the written comment, explaining that whether you're going to incorporate their suggestions or the reasons if you're not.
Board wish to include the modifications that are involved in this letter versus the language that we currently are proposing?
I don't think so, but let me just ask Mr. Cleveland, since the letter came from him, would, after having heard our rationale and what has come up here, do you think that what we have told you and how we came about formulating these rules, does that satisfy what you have given us in the letter?
Excuse me, yes, I believe it does. I believe it does. The discussions that came about at the recent Board of Directors meeting was we had several.
Sorry, sir. Could you come up to a microphone, please? I'm going to go ahead. Since you're on the sign-in sheet, I'm going to consider this your oral comment, too.
You can just have a seat at the table. That's for you guys. If you want to sit there, you can sit at either one of
Sit
the
over there.
tables.
Yes, sir. I believe it does. Those concerns arose from several members that were licensed out of state, and one of them was a considerable distance away, and some of the continuing education requirements would have required him to travel halfway across the country to take a 2 or 3 hour minimum standards and ethics type class, and so he had no intent.
May I interrupt you, Mr.
Sure.
Cleveland? We're not talking about continuing education. We're talking about rules of conduct.
Right, but what I'm saying is he voluntarily surrendered his license to keep from having to do that, because he had no intention of practicing in that state any longer.
Yeah.
So that was some of the concerns that were raised there, and like I said, and then having the explaining the board's intent with the for subparagraph A. I think for me personally, I think your explanation of that rule, I think it satisfied me personally of what the board's intent is.
All right, and that's fine. In that case, as far as I'm concerned, and I agree with him, I don't see any reason to change anything that we have already put into this then.
We'll vote on any proposed changes after all the comments are in, but I was just checking. All righty.
Thank you.
The next person is Mr. Craddy. Would you like to make some comments?
Unfortunately, I don't agree. 3 times I heard it said it's not the intention of this board. Well, I know that's not the intention of this board, but I've seen states where vindications come into boards' actions for some are aware of some cases where that's happened in other states. And I'm not talking about this board by any means. It's the future I'm looking at. It needs to be nailed down a little tighter than just to leave it so wide open and broad. And that was
Well, we try to use a matrix to assign any kind of discipline that we do in order to avoid being arbitrary or capricious. Because you're right, we can't treat anybody any differently than anybody else, and the board has to assure people that that's the case. As a matter of fact, when complaints are presented to the board, they're presented anonymously, and nobody knows the identity of the respondent. And they're given what's called a probable cause synopsis. The details are not really given to the board. The board is only given enough information to determine that there is a possibility an allegation has taken place. So we strive to protect the identities of the respondents for one thing, and for another thing, we also try to make sure that discipline is evenly applied to everybody, because that's the way that the board is charged to operate. I understand what you're saying, and I can see where some boards in other states would be that way. But we have to stick by precedent with this board no matter who the panel is. The board continues going just like a baseball team, even if there's different players. They have to abide by precedent. They can't wander off and do something that seems out of character.
Address subparagraph B, the voluntary surrender, that hadn't been addressed to me yet. I hadn't quite understood what, I mean, I understand what you're saying, but that word voluntary surrender, there's so many people that have voluntarily
Mr.
surrendered.
Murphy, may I address that?
Yes.
In other jurisdictions where I'm licensed, Mr. Craddy, when I review their disciplinary actions, there are actions that would lead to possible revocation of a licensee, and in lieu of the licensee having his license revocated, the licensee voluntarily surrenders it. And that's really the application of the way that that's written.
Similar to turn in a resignation instead of being fired.
That language is in the settlement offer. When NCAAS reports, that'll be in the decision of the board. The respondent voluntarily surrenders in order to avoid further disciplinary action. It's specified why they did. I'm like you. I don't like surrenders, because if the board is going to remove somebody's license, the board is going to remove it themselves. In some states, though, they do voluntarily surrender, and that has the effect of a revocation. But that language is specific in the order. Just a regular old surrenders is not discipline. It doesn't have any effect. Does that help?
May I ask a question in regard to that specific section? Is there anything here that suggests that it is a mandatory action of this board based on subsection B there? Should a license of a registrant have their license in another state, whether it's voluntary or suspension or revocation, does this mandate this board to take action on their Tennessee license because of actions in other state, or is it
It's discretionary.
Okay.
It's maybe deemed to be misconduct. Typically, this board, if somebody's revoked in another jurisdiction or suspended, we usually don't do the same thing. We'll do something, like if they're revoked, we might suspend them for 6 months. It's kind of rare that reciprocal discipline is the same as the discipline in some other state, unless it's particularly heinous. The facts stand on their own bottom, but you could issue a letter of warning if somebody's suspended in another state. It's just deemed to be misconduct, but you're not required to do anything particular.
And that letter then would serve as notice that be careful,
yeah,
because you are practicing in Tennessee, and
we know what happened.
Yes, we know what happened, so observe the rules of conduct and what have you. Okay.
Depends on what they did and how severe it was, and it just means that it is disciplinary to be disciplined formally in another state. And formal discipline is assessment of a civil penalty, revocation, suspension. Informal discipline is a letter of warning, and we're not even reported those, I don't think.
I might address the board. Perhaps considering just adding the word disciplinary in front of voluntary surrender makes it clear that that's a disciplinary voluntary surrender as opposed to a, I just don't want.
What you're suggesting, Ms. Avers, is dealing with voluntary surrender due to discipline or based on discipline or a disciplinary voluntary surrender, however the verbiage
Disciplinary surrender, perhaps. Surrender suggests that it's voluntary, so it could be disciplinary surrender.
I know a lot of states use the term voluntary surrender, and it usually is in order to avoid being revoked. You know, instead of going to the formal hearing, they just surrender it as a disciplinary action. I also know that many times there's non-disciplinary surrenders where they just don't want the license anymore. And I just was thinking inserting the word, excuse me, disciplinary in front of voluntary surrender just made it a little more clear that that's not the voluntary surrender where I just don't want the license anymore, but leading up to a complaint, and it's considered a disciplinary voluntary surrender where they agreed to it. It was just a thought.
I personally don't have any problem with your suggestion, Nicole, from a standpoint if that gives it the additional clarity, and it's also actually in the spirit of Mr. Cleveland's letter, because he described in his letter as a punitive action by a licensing board, which a disciplinary action certainly is a punitive action.
Help you, Mr. Cray? Okay.
What verbiage would we, do we just want to add disciplinary, just the one word?
I think just inserting that one word in front of voluntary surrender just makes it clear that it's that type of voluntary surrender. That's my recommendation. Proceed as you think is appropriate.
What we'll do is we'll insert that at this time because it was due to that question, and then when we go back for our review, as we come all the way back through them, we'll make sure that we address that so that on the copy that Rob has for our final vote, that'll be placed in it.
Okay, Mr. Ward?
No comments at this time, just here to observe.
Okay. Mr. Tussar?
No comments on that.
Okay, then I think we have all of our comments in. Let me see here. Right, we have all of our comments in, so Mr. Chairman, if we want to go back through here and make any changes, I've got one more suggestion.
Go right ahead, Mr. Herndon.
I've been told that the word, and this happened in the engineering board as well, the word he is shown throughout the chapter to indicate a registrant. It's been suggested from more than one source that should be changed to registrant to be gender neutral.
So we also have the term his in there also a lot, and I had actually had that same question because of gender neutrality or whatever it's called.
It's come up in other boards, so if you could make the suggestion that wherever it appears, he or his, wherever it appears, would be substituted for registrant or registrants.
I don't have any problem with that, but in certain sentences, and we need to go through those, it will be repetitive or cumbersome.
We can't really use it's.
Right. Yeah, we don't call it it.
So we got to there.
Always do the old-fashioned his/her.
Guess we could if it makes it easier in certain passages.
Well, if we're to that point, then, Mr. Herndon, if we can, we'll start with subsection 02, proper conduct of practice, and go through those, and let each member, if they have comments, speak to those, so we can begin to formulate the final document, if that's fine, based on, minor changes.
Any suggested changes to rule number 2, proper conduct of practice?
Okay, any?
No, sir.
Okay. We'll go to number 3 then. I think number 3 is where we start incurring our his and he, I think.
Paragraph 2, I think, is the first instant.
Which he is qualified. So do we want to strike that and put in the registrant?
Registrants may accept an assignment requiring education or experience outside of the registrant's field of competence, but only to the extent where his or her services are restricted. Those phases of the project in which the registrant is required, is qualified.
Hey, number 3, I had a question. In regards to the and or that is between signature and the word seal, would it be more appropriately read if it just simply said or?
Yeah, there's no reason, I don't think, to have and in there.
Later in that particular sentence, it says in which he lacks competence, so that would be
Registrant.
the registrant. And then again, later it says prepared by him or
Or
under his.
her. We'll just say him or her.
Okay.
And then that next following his would be the registrant.
I do have a question on item 3 there. Right after the and or that we just talked about, the and or seal, to any plan or document. I guess the first question would be, why do we have both? Why couldn't it just be document? And the second question following on that is, we had a discussion yesterday about surveyors and plats versus plans.
Strike plan or, and just have document. Because that would be confusing. But that was in there before, but we can take it out now. Plan, I think, incorporates, well, everything, field notes and sketches and proposals. But document is fine.
Also, following on that same item, on the third sentence line.
Yes, it would go away too, plan or.
Yes, sir.
Paragraph 4.
No problem.
Okay. Five looks okay. Say the registrant here.
Yeah, well, item 2 does have a his on the final line there.
It does, you're right.
Propriety of his testimony.
Thank you, Jay.
Registrant. Next rule. Put his or her. Disclose the circumstances to his or her employer or client, just to avoid the using registrant all over.
You're just doing the his/her or?
His or her. Just
Okay. On number 2, NCAAS made one change. Their change is, it says the registrant shall avoid all known or potential conflicts of interest. And then we got a his there we got to get rid of. Also, after the word any, prior to business in the second sentence, there's a semicolon. I don't think that belongs
notice
there.
that. Yeah.
But NCAAS in August of this year made a change, adding the words or potential.
Also a his on the final line there as well.
Yes. On number 3, NCAAS added 2 words in the last sentence before the final phrase, by all interested parties. They added in writing, by all interested parties. His or her, wouldn't it, Rob?
Registrant's organization.
Number 5, in the second sentence, NCAAS made the following change. It says, without the prior consent of the client, they eliminated the word or, placing a comma, employer, and then added or public body on which they serve, except as authorized or required by law.
Public body.
Public body on which they serve.
That one more time, Tim.
Okay. Second sentence, without the prior consent of the client, comma, employer, or public body on which they serve, comma, except as authorized or required by law. Ready for number 7? 7, number 1, has a fairly good change in it from the NCAAS. Let me read it the way they wrote it. The registrant shall not partner, practice, or offer to practice with any person or firm that I guess it'd be the registrant because it's got a he in it. The registrant knows or has reason to believe is engaging in business or professional practice of a fraudulent or dishonest nature. That's kind of a long one. They eliminated, after the word shall not, they eliminated knowingly associate with or permit the use of the name or firm name in a business venture by. They eliminated all of that. And replaced that with partner, practice, or offered to practice with. Second sentence, after the word firm, they changed the word which to that. There, we could change it to the registrant.
Yep.
Tim, I have a question with one of the items that you're proposing to be eliminated,
Yes, sir.
and that is the permit the use of his name or firm name.
Mm-hmm.
How do you think that those are covered with what you're suggesting to be replaced with?
Well, according
Or
to
should it be
the
added with it?
Yes.
It does.
Practice covers offers
Yeah.
to practice.
according to the UPLG committee of NCWS, they said that that was stronger language than the language that they previously had.
Our statute says you can't even indicate that you're capable of surveying because that would fall into practice. Certainly if you use your name, you're offering to practice. So I think it would cover it.
Paragraph 3, we want to make sure in subparagraph B that we add the word disciplinary in front of volunteer.
That you have residents shall affix their seal.
Registrant shall superimpose his or a rubber stamp and a date of signature across the face and beyond the circumference of or adjacent to the seal and documents to which the registrant seal is affixed.
Then that would be, should be fine, shouldn't it? There would be
I would think.
gender, not gender specific, I wouldn't think, would it?
You have a question on item 4 under seals. Seal and signature shall be placed on all original copies. That kind of, is that supposed to be original documents, perhaps?
You can make
you have
multiple
original
copies of a
copies?
plat and have to stamp every one of them if you're making duplicate construction documents. If you're sending something out for bid and your plat's part of construction documents, you duplicate the plat, but you have to seal each one of them originally and sign it. That's the way I've seen it done. I think that's the way it contemplates it, sending it out to different bidders.
Plans or what have you, and you're sending out multiple copies, and I'm talking about 60 sheets or something are in this thing. That's a whole lot of samples.
Yep, I've done it before when I was doing design. I've had to do that before when you were sending plans out for a hospital to several bidders, and in a state where they still use crimpers. That was painful. It had to be done. They had to all be originally sealed. The chair recognize.
Yes, Chair, recognize Mr. Craddy. If you come forward to the microphone, please.
Ask for some clarification on that number 4. When I do a plat in the state of Tennessee, I have to live sign it and put a live seal on it. So will the plat have 2 seals on it and 2 signatures? One live and one reproduced?
I think copy contemplates you finish the plat before you seal it, and you make copies for different sets, and you have to seal each duplicate.
The original tracings.
Right. It just depends on the situation. Whenever you're sending something out for review, it has to have a seal on it. It might be a tracing, or it might be several copies of that tracing, but they all have to have a seal on it with your signature.
I guess what I'm foggy in my brain is my drawings that I'm storing in my flat files. Will they have a seal and a signature on all of the tracings in my flat files?
Not if it's just a working document. Anything you send out for approval or for recording, anything that's sent out for review by somebody else has to have a seal on it.
Reproduced.
Even reproductions of it.
Okay.
For instance, if you have a subdivision that's going out to bid for 15 people, like Mr. Northcutt said, and each one of these bidders is going to get an original set, then every copy of your plat that goes on top is going to have an original seal on it.
I understand that. But what I can't understand, maybe pardon me, is it says seal and signature shall be placed on all original copies, tracings, and other reproducible documents. So that leads me to believe every document that is going to go out has to have the seal and signature on it. But then when I carry it to the registrar's office, I have to live sign and seal it.
This is sort of getting archaic. You remember vellums and mylars and stuff that were reproducible. You would seal that and then when it was reproduced, after it was recorded, it would have your seal on it.
Well, Mr. Craddy, the most common misuse, I guess, of that is, for example, legal descriptions. All surveyors don't stamp legal descriptions. They're supposed to. Surveyors reports are supposed to be stamped. And I clearly understand what you're talking about because we have to have wet signatures for all recorded documents in our county also. I mean, as far as that language, and to address your comment, Jay, as far as that language goes, in the spirit of what we looked at a while ago, specifically, we could really eliminate original copies tracings and put in the word documents or other reproducible documents. Or in other words, reword that a little bit to say, in other words, the intent, the spirit is that anything you produce as a professional, you stamp and you sign. That's the spirit of where that's going. Now, if we need to massage that a little bit, I don't have any problem with that.
Well, let me. I produce a plat for a one-lot subdivision to go to the Planning Commission, and I stamp my original, and I take it to Reprographics and say, reproduce this because the Planning Commission needs 14 copies. It has my stamp and my signature on it. Should it not have that, and when they reproduce the plat, then I stamp each and every copy that goes into the plan.
Well, that's a recorded document.
Well, the original will be recorded, but as far as the Planning Commission themselves, each member of the Planning Commission gets a copy so that as we talk about it. So,
And more often than not, those are either folded up and thrown away, or one or two of them's kept, or they're given back to you. I mean, we've all seen that.
yeah.
So I mean, so you have a document that has all the stuff on it, but it's not technically used for anything more often. Cool.
And in that case, the reproduction of the signature.
Well, paragraph 2 above contemplates preliminary,
Thank you,
not
Mr.
for
Craddock.
construction, recording purposes, or implementation.
Yeah.
Paragraph 3 is sort of contemplates if it is required to be sealed. This is how you seal it. And paragraph 4 talks about documents that have to be sealed. But for what you're talking about, if it's not supposed, you seal it, but it's not really recorded. And is there some designation on that document that says that it's not to be recorded?
Probably not on the reproduction. There's nothing that would say that unless I take the original and say, hey, for recording purposes, and then you make another one and says, hey, this is for planning.
Well, for example, in Knoxville in particular, I know of very few surveyors in Knoxville that actually had any kind of blueprint machine for years, and they would take and sign their original tracing to, for example, like Knoxville Blue, a blueprint company, and they'd say, look, I need 10 prints of this, and they would run the prints, and then that's what the client would actually get, would be those prints. I think the spirit of that particular section is to make sure that all documents of your product have that seal and signature on it. I think that's the spirit of it.
That's what
Now, if we need to massage the wording, we can certainly do so.
I can live with the spirit.
Put your original seal on it. They want a copy of the plat.
Mm-hmm.
Do you have to re-stamp it with your?
I would not think so. I think that's what I was getting
Well,
at.
I
would
know,
not
I think it's
so.
confusing there.
Yeah.
Because now y'all are saying that every time you make a copy, you got to put your original stamp.
Oh, it just says that the seal and signature will be reproduced when the copies are made. It's just simply saying, the way I infer it, and I may be wrong, it simply says that all of your work products will be sealed and signed.
Yeah.
Whether that work product is now a reproduced copy of it or it was an original document, all of those will be sealed and signed.
And those that are to be recorded have the original.
Yeah. But that's
Sealed.
sort of a
Wet signature.
secondary
That's right.
requirement by the
Yeah. Okay.
individual entity that's recording the document.
Bart, does that take care of?
Yeah, I was just confused
Okay.
was all. I wasn't making any suggestions. I was just confused.
I was just going to say that ties in well with the further down where y'all get into digital signatures, because that's a whole different ball game. When you're putting a digital signature on there, that puppy's on there from the get-go. Now, a registered deeds may still require you to wet stamp it, but that sort of sheds light on the whole conversation, because that thing's going to be on there as soon as you print it. It's going to automatically be reproduced on any copy you create by how y'all worded it. So,
Or could you state your name for the record?
I'm sorry, Stephen Ward.
No changes needed?
Well, I'm certainly open to any changes, Jay.
I'm fine with it.
No,
I'm fine with it.
I'm fine with
Like the
that.
spirit of it
Everybody
says so.
fine with the spirit of it, or where we're going with it?
Yeah.
No changes to it.
Okay.
Okay.
Chairman, can I ask a question?
Please identify yourself for the record.
Alan Crawford, good morning.
Good morning, Mr. Crawford.
I've always had a concern about this, but it grows with time because, as we all know, with the proliferation of digital media, we're constantly sending things to people, whether it's a PDF file or a drawing file or whatever. And I've actually seen copies of drawings that I've never printed that might have been sent from a computer in my office in a PDF format that was for preliminary review by a good client. But then they'll print it from their office and somehow winds up in the hands of others. Now, I'm not happy with that, but it happens. But I'm concerned that this body might get a copy of that, see my seal is not on it, and I really had, the only control I had at any point in time in case my client would not be happy. So,
Take you back, Mr. Crawford, to our recently changed standards of practice, and the dialogue that's used in the standard of practice is that that work product that you're describing is your intellectual property. And as you'll see when we get to digital signatures here in a little bit, I think that it's inherent that the registrant should take whatever means is necessary to protect that intellectual property, especially when you're sending it through electronic means. Now, I'm not chastising you, don't get me wrong. I'm just saying the world we're in, you're 100% right, and it's going to become more electronic as far as movement of things. I haven't had a client yet, as far other than a large firm or something like that that's wanted strictly digital product. As far as John or Jane Q. Public, when I'm doing a lot survey or 100 acres or something, they've not asked for a digital product at this point. They eventually will. Now, I've had them ask for PDFs clearly, but I mean, as far as like an AutoCAD drawing or something of that nature, they've not asked. Other entities ask for that. So, not to say that I do it correctly, but I certainly try to do a whole lot of CYA when that product goes out to make sure everybody knows what it is, what it's for, and what its intention is. And that's, like I say, you'll see in a little bit here when we get to the digital language. That's why it has all those protective mechanisms in it, to where the seal and signature goes away if somebody modifies and all that kind of stuff. And unfortunately, that's the world that we're already in, but it's going to become more real to all of us.
That answer
Thank you.
what you need.
well, I think it's an answer, maybe not the one I was hoping for.
Well, continue to lead us to the trough a little bit better then.
Okay.
All right, so we're good through 4, is that correct?
Yes, sir.
Through 4 then.
Yes, sir.
In item 5, I just want a clarification to make sure I'm reading this correctly. Obviously, the first line addresses that if a document contains more than one sheet, that the first or title page may be sealed, which infers to me that only one of those multiple sheets needs to be signed and sealed. Is that correct? I'm not trying to make a complicated question. I think it's pretty
I think
straightforward.
the inference is there, but I don't think that was the spirit of thing. I think that every document,
Like every sheet,
every sheet
that may be
needs to
missing
have a
something.
seal on it. And that question was asked of me less than a week ago by a major firm here in town. They were sending out planning documents and what have you, and I said, if you're sending it out of your office for planning, you need to have your stamp on this thing. Just the title page, but every page, because you're certifying whatever information is on the subsequent pages that go out in addition to the title page.
However, don't you think that that's already covered if on multiple sheets you have, designated sheet 1 of 4, 2 of 4, 3 of 4, 4 of 4, et cetera, et cetera. If you're stamping any one of those sheets, by relationship there you have that there are multiple sheets contained within by designating sheet 1 of 4, 2 of 4, et cetera.
I'm not sure that I would have a problem with that aspect of it, but when you put together construction documents, your sheets are not necessarily sequential, and they may be found at one place or another throughout a set of documents for planning purposes and construction, and I think that seal and signature needs to be on each one of those individual documents. If you're doing 1, 2, 3, or 4 of a subdivision that is section 1, 2, 3, and 4 of a particular subdivision, and it's all in sequence, I don't know that I would have a problem with that. But there again, there's a place for space to put a stamp on it. I would preferably I would do it.
If I recall, Jay, this language came from the model law of NCAAS, and if you read further into it, it really is a little wordy. I think what they were trying to say was, and you have to realize that NCAAS also deals with engineers, and their methodology is a little bit different than ours, obviously. And if you read on down further, the third sentence actually says, in addition, each sheet shall be sealed and signed by the registrant or registrants responsible for that sheet. So it actually ends up saying what you're saying. You're 100% right. All sheets should be stamped. But what it was trying to allude to, I think, and maybe we need to reword it a little bit, was oftentimes in engineering drawings, if you have a set of plans, for example, let's say you have a set of civil plans for a site, a lot of times they won't stamp that first page, and then they'll stamp the other pages, and it may be different people that stamp those pages because they did different things. One person may have done drainage, one person may have done the grading or whatever.
Let me stop you right there, Tim,
Yes,
with a question. Where you picked up on there in the language where it says, in addition, each sheet. I read that to be still tied to the sentence prior, which was about 2 or more registrants.
Possibly that sentence needs to be the second sentence instead of the third sentence. How would you feel about that?
If that's the intention, but I read the very first sentence saying that if it's a survey only plat that's multiple pages, that I can sign and seal just one of those pages is the way I'm reading it.
Well, we need to change it then.
Yeah, I think so.
Yeah, I have no problem with that at all. None.
Well, honestly, I don't know. I mean, my opinion may differ here than what I think the other members of the board are saying here. But quite honestly, I'm comfortable with the signature, and the seal of a surveyor being on one and only sheet, as long as those sheets are numbered. I think he takes responsibility for all sheets. Now, if we're talking about a set of engineering documents where another registrant is involved, as in another surveyor or another engineer of some sort, then yes, I agree that the sheets that particular licensee is responsible for should be designated and noted. But if it's a surveyor-only subdivision plat that has multiple sheets, I have no problem with the last sheet containing signatures of, it could be a planning commission member or whatever, having the signature that says, with the certification by the surveyor. In fact, I can tell you that's generally the way it's done, as best I recall, in Shelby County, in that area, that there may be multiple sheets to a plat of some sort, but the last sheet is always the signature sheet, and you see everybody on there. You're not seeing every single sheet stamped.
Well, in East Tennessee, it works just the opposite of that. We have to stamp every sheet. In other words, if we had a 5-sheet subdivision, we have to stamp every sheet.
Really?
Even though the planning, all the other superfluous signatures that have to sign it may all be on one page.
Well, I do understand the intention and the safeguard that I
Yeah.
think you're suggesting there by stamping each and every sheet. I understand that, and I, quite honestly, I can't disagree with it. However, I do think the practice in the area that we are is that typically one sheet is signed and stamped, and is acceptance, and that by that is acceptance of all sheets that are involved in it.
I
Quite honestly,
understand
I mean, I can't imagine putting out a 15 or 17 page survey, which is not uncommon, and stamping and signing every single one for the 10 copies that need to go to the 10 different attorneys that want to see it. Wow, that's a lot of labor. When one sheet that says I accept it and I've done the work that's shown on this survey has already been done. Am I out of the ordinary here? Is this?
The only familiarity I have
I mean, I understand what you're saying.
That doesn't always require a stamp on every sheet is some situations with Alta surveys. But even then, my practice is to stamp every sheet that's my product.
Now, I do understand the point that if it is a set of construction documents or something to that effect where there is another professional involved, such as either it could be another surveyor or another engineer of some sort, and you need to specify what it is you're responsible for, I can understand that. That makes relevance to me. But if it's just a survey or a plat or a survey only, and I'm the only one certified to it, I don't think it's necessary to burden the surveyor on stamping every page on that when it's by your signature and your certification on there. You said, I've accepted it. I'm responsible for this. Stamp, sign, done.
Yes, Mr. Ward?
My only thought on that would be, me personally, my stamp's going on every single sheet because I don't want to give somebody the opportunity to modify sheets 2 through 4 that don't have my seal on there. They have a much easier time of taking my CAD file, let's say I've given them a CAD file, sheets 2 through 4, they can print that baby out whatever they want on it if I don't have it sealed. Me personally, I'm stamping and sealing every sheet. Maybe electronically, but it's going to be on there.
Jimmy Cleveland, I can definitely see where Jay's coming from because he and I practice in pretty much the same proximity, same areas of the state. And Shelby County is a whole different entity in itself. The way they operate it could get somebody in trouble if they're not careful.
Let me just kind of wrap this up and to say, what is the understanding of item 5? Is it that every single page will be stamped and signed by a surveyor on his documents? I just need a clarification on that question.
That's my understanding, yes, sir.
It is?
Yes,
That's
sir.
my understanding.
Okay.
And it goes on to allude that if there is something that's out of that surveyor's expertise and there's another professional, whether it be engineer or another surveyor or whatever it may be, then that may also be included in that multi-sheet scenario.
Okay, if that's going to be the case, then I would like, and you made this suggestion earlier, that we move sentence number 3 that says, in addition, each sheet shall be sealed and signed. We need to make that the second sentence that follows the first sentence. Because the way I was reading it originally, the way it's shown was that the portion where it says, in addition, only applied to when there was 2 or more registrants.
I think that gets closer to our discussion, don't you, but making that change?
Yes. Yes. If you're suggesting moving sentence 3 to make it sentence 2.
Yes.
Then I think if we do that, then it does say that each and every sheet shall be signed.
Mr. Herndon, does that seem to fit also? And as far as our members here that are attending, is that
What's important is that
what we're doing?
What's important is that you get it the way you want it to be, and that
Yes.
the registrants understand it. So you want to move the last sentence.
The sentence that begins with "in addition."
In addition, put that as the second sentence, and then the sentence that starts with 2 or more, that's the third sentence. That's what you're saying, right, Jeff?
Sentence 2 or more is sentence 3. In addition is sentence 2.
anything on number 6?
No, no, 6.
Okay. Number 7. I realize that some of these on the seal and signature are a little bit redundant, but Mr. Crawford's benefits, having just came in, I spoke earlier that part of the reasoning behind expanding these from what we originally have written toward a basically a line item. If someone has a complaint filed about a specific area,
Teeth.
it gives us those teeth, yes. And that's what we're looking for. We're certainly not on a witch hunt to find anything for anybody, but if somebody brings it to our attention and it is legitimate, we need to have something that supports us. In item number 7. Okay, we're down to number. Number 9, we actually had a situation where that came about, just for the group's edification. A situation where a surveyor was working on a project and he died. And the client was wanting his project finished, but the surveyor didn't have anybody else in his employee or his firm that was licensed. So another surveyor who was a friend of the individual that died agreed to take on the project. And he actually submitted a letter to this board to ask us if he could, go ahead and, review the work and finish the work and then stamp it if that was okay. And that's really the background history behind that particular item right there. That very scenario that happened, I guess, about 4 or 5 years ago. It came to the board. We're good through number 9? Okay. Number 10's language is strictly from NCWS. It also is similar to, if Rob, correct me if I'm wrong, it's also similar to the engineer's language, and it also fits the Uniform Transaction Act of the state of Tennessee, which the legislature passed. So that's a whole lot said, but for what's there, it meets all the criteria that's out there. And as Rob said earlier, we do try to, some of these things that we can parallel the engineer-architect profession so that the legislature is not seeing two completely different things on the same entity, same issue.
Mr. Chairman?
Yes, sir.
With regards to that, the Leonard Tusar, with regards to that, it says computer-generated seals. Computer-generated seals, well, the original seal has to be a 2-inch diameter seal, as described in paragraph 2. Would it be prudent to put in computer-generated seals conforming to paragraph 2, so that you don't get a computer-generated seal that's only, 1 inch in diameter? Prudent?
Mr. Chairman?
Yes. Alan Crawford.
Personally, I think you're covered on that, but with respect to 2 inches in diameter, I'm not concerned that this board would take unjust action because something had been
Scaled down, yeah.
I've seen that several times too.
Well,
especially.
we have an item in here that discusses that very thing, that the seal should be the correct size in all instances. But I think the spirit of where you're coming from, Mr. Crawford, I don't think the board would unduly penalize somebody because someone else copied it unbeknownst to them and it come back different size.
Not this board.
But the next board down might.
Right.
That's my concern.
Yeah.
If it would be all right, we'd like to take a 10-minute break, please. I know that's a little unusual in the middle of this public hearing, but we have a need that we need to take care of.
Okay, we'll adjourn this meeting for 10 minutes.
After the report.
How you doing?
Okay. I think everybody's more in the mood now to continue to work. It's about 10:45, and we'll reconvene this public hearing. And I think where we left off was on item number 10 on page 6. Rated seals.
I guess I should call the meeting rulemaking hearing back to order, just as a necessity. Okay. We're now on paragraph 10 of our review of rule number 8.
I do have a question on the second sentence of item number 10. It talks about a handwritten signature, which I'm fine with, is placed across the seal, and the date is written. Is that also suggested to be handwritten as well, or could it be computer-generated written?
Well, the differentiation there is between the handwriting, it's a computer seal and a wet sign.
Yes, I agree.
Versus the
And what about the date?
The digital signature.
I agree with you.
Yeah.
I understand that part. I have no problem with that. My question is on the date. Is the date handwritten as well? Wet written date as well? Because well, and I'm being nitpicky here, but one is handwritten and the other one is written. Right. Should they both be handwritten? I think that's the intention.
The intention is that you sign it and date it to
right.
show that you signed it on that date.
All right. So can I make the suggestion that both of those read as handwritten?
Sure.
I think that's the intention, and
Sure.
I think it's obvious, but I think it should be clarified.
No problem. So we have a handwritten signature and a handwritten date, where it's a computer-generated seal.
Yes.
Which is pretty common. But that's a very good point. Else on paragraph 10.
Second sentence of the last paragraph. Any hard copy printed from the transmitted electronic file shall bear the facsimile of the signature and seal and be a confirmation. That's supposed to be, should we put shall be a confirmation? I don't guess it matters.
It's in the first sentence of that last paragraph, a digital signature that uses a process approved by the board. Has this board formally approved any digital signature processes?
No.
The approval of this rule, the rule,
Gives
once
us
it goes into
authority
effect, gives us the authority
to do
then
that.
to do that.
Thank you.
But we have to have that in there to be able to
Yep.
do that.
Yep.
Not in the NCAAS language, Rob. The shall. If you want to put it in there, that's fine, but it just wasn't in their language.
Okay.
Clarify anything?
It just seemed a little awkward to me. We don't have
If
to
you
put
feel
it
like
in.
it needs to be in there, I don't see any significant change whatsoever as far as the intent of what it says.
Sort of describes the mandatory nature of it.
Hey, if you want to insert the word shall, it's fine.
Guess we're done with Rule 8.
Or
Then.
did we insert or not?
I'll put it in there.
Okay, all right, we're going to insert the word shall. All right, we're ready now for rule number 9, responsible charge of service. Have any
Paragraph 4.
changes or anything?
No, I don't see anything.
In paragraph 4, Donna mentioned some corporations, partnerships, and firms maintaining any place of business in this state for the purpose of providing or offering to provide land surveying, said ING services.
Still don't see it. Right.
Chairman, Alan Crawford.
Yes, sir.
I may be in trouble here. On item number 1 under this section, the 30-hour per week requirement, do I just need to make sure that my pay stub reflects that I work 30 hours, or do I actually have to do something?
Ain't answered that question, Mr. Crawford.
Boy,
Which one of us do you want to be in trouble, you or us?
it doesn't say work,
Does
it
this
says
count?
employed.
Am I working right now?
Are we, everyone good with 9? Any comments?
Just real quick, the definition of firm, when you say corporations, partnerships, and firms, does that include a one-man operation type thing? It does. Thank you.
Corporations can be only one person.
Thank you. Yeah, that's
You know,
true.
We actually discussed
Well, if they're
that,
not
I think,
incorporated, though.
when we brought this up. Also, sole proprietors and LLCs and that type of thing falls under that same domain. I asked that same
Firms?
question.
It does, okay.
Same
Thank you.
question before.
Thank you.
And that was a question that I received from the Northeast chapter of TAPS also, was if those were included.
There's lots of one-people operations, I'm sure. One new rule, and this is a duplicate of the engineering firm rule that requires engineering firms to disclose to the board that they are here in Tennessee doing business and who their registrants are.
I think this will be a plus to our profession. I really do.
I don't license firms. This is just disclosure. This is just notifying us that you're here.
Similar rules in some of the adjoining states, I believe, already in effect.
Yes, and also in some of the adjoining states, they have the authority under their rules and statutes to also charge fees for this also in other states. Mr. Herndon, I think that we have carefully reviewed one more time our document. We've somewhat massaged it to incorporate comments that we've heard today from the public, also comments of change from NCEES, and comments from yourself and comments from the board. So I think we're ready to turn it back over to you.
Okay, now we need for the board to approve any changes. So we need a motion to approve the proposed rules as revised.
Approve the proposed changes.
Approve the proposed rules as noted, as revised.
Okay, we have a motion. Do we have a second?
I'll second that.
All right, we have a second. Is there any further discussion? If not, I'll call for the question. All's in favor?
Aye.
Opposed? Okay, motion carries.
Okay, one last thing by statute we have to do. I've handed out this document here. It's a regulatory flexibility analysis. Okay, I'm going to read this into the record, and on the second page there's a series of 6 questions and suggested answers that the board needs to consider before we can conclude the rulemaking hearing. The Regulatory Flexibility Act, Tennessee Code, annotated sections 4-5-401 et sec, requires that as part of the rulemaking process, pursuant to that same statute and section, all agencies shall review all proposed rules and the effect that the proposed rules have on small businesses. The Act requires that as part of its analysis, each agency shall prepare an economic impact statement as an addendum to each rule that is deemed to affect small businesses, which shall be published in the Tennessee Administrative Register, filed with the Secretary of State's office, and made available to all interested parties, including the Secretary of State, Attorney General, and the House and Senate Government Operations Committee. This economic impact statement shall include the following: the type or types of small businesses and an identification and estimate of the number of small businesses subject to the proposed rule, the projected reporting, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for preparation of the report or record, a statement of the probable effect on impacted small businesses and consumers, a description of any less cumbersome, less intrusive, or less costly alternative methods of achieving the purpose and or objectives of the proposed rule that may exist, and to what extent such alternative means might be less burdensome to small businesses, a comparison of the proposed rule with any federal or state counterparts, an analysis of the effect of the possible exemption of small businesses for all or any part of the requirements contained in the proposed rule. Okay. The Tennessee Board of Examiners for Land Surveyors convened a rulemaking hearing on October 24, 2013, in order to consider amending current board rules, standards of relative to our rules of professional conduct. These amendments concern updating the rules of professional conduct that apply to all the board's registrants. The rules contained in the notice of rulemaking would replace the current relative requirements with the proposed updated standards. All right, and then there's a series of questions that you see. Question 1, types and estimated number of small businesses directly affected. And the suggested response from the board would be these amendments would not impact small businesses because the board licenses individuals, not entities.
Want us to motion these individually, Rob, or do them collectively?
It's up to the board if you want to look at each one and vote on each one, or if you want to do them all.
Whatever y'all's pleasure.
Let's go through all 5 first, and if we're in agreement with it, we can wrap it into one.
Thank you, Jay.
Okay. Number 2, projected reporting, record keeping, and other administrative costs. There are no projected administrative costs as a result of these amendments.
Brief question on that one.
Okay.
It may be minor, and hopefully all will agree with me that it's minor. Was there not a, under the new rules that we were proposing, was there not additional reporting to be made to the board of the, was it corporate officers? Did I read that right?
Yes, sir.
And would that, although minor, is that not an additional administrative cost that may be from this? It is minor.
I would choose to use the word minor as opposed to no. I think that's in the spirit of where you're going, Jay.
It is, yeah. I mean, I'm looking at big picture.
Yes.
Are we talking big picture here, or are we talking small, minor stuff? I didn't know what was to be considered as record-keeping administrative costs.
Nicole and Donna will have to have a system to keep up with the firms as far as who their registrants are, and that's part of this rule.
I mean, I think there's administrative costs associated with not only the registrant himself. He's got additional paperwork to do that has to be reported, but especially on the office here that may have some additional cost in incorporating that additional paperwork, filing, record keeping, things like that. I'm sure in the big picture it's minor, so I don't know if that's considered for item number 2 or not, but I just wanted to get a feel for it.
Hopefully it'd be, I would hope that we might be able to do it online, just have an online form, and they would be able, with this new licensing system they're going to be using and so forth, and it would be rather simple and painless for anybody.
I would hope so,
Yeah.
Okay. I didn't know if that's something that we're talking about here in item 2, or if that was.
We say minimal costs.
I think minimal would.
Okay. There are minimal costs projected as a result of these amendments. There are minimal administrative costs projected as a result of these amendments. Number 3, probable effect on small businesses. There is no expected adverse impact on small businesses as a result of these amendments. Number 4, less burdensome, intrusive, or costly alternative methods. The board knows of no other alternative method to achieve the goals exhibited by these rules. Number 5, comparison with federal and state counterparts. There are no federal counterparts to the issues addressed by these rules. Number 6, effect of possible exemption of small businesses. There will be no exemptions created by these rules.
Everyone agrees with all 6 items as the responses have been read and amended. The chair will entertain a motion.
So moved.
Second?
Second.
Okay, we have a motion second. Is there any further discussion? All those in favor, say aye.
Aye.
Opposed? Okay, motion carries.
Last item, impact on local governments pursuant to Tennessee Code Annotated, Section 4-5-228. The Board of Examiners for Land Surveyors licenses only individuals and foresees no financial impact on any local governments. The word being foresees.
Board agrees with this. The chair will entertain a motion.
So moved.
Second?
Second.
Okay, we have a motion second. Any further discussion? If not, all those in favor say aye.
Aye.
Opposed? Okay, Mr. Herndon.
Seconded that. Okay.
That concludes this rulemaking hearing and comment period. Thank you for being here today. Now, we need a roll call vote so we can mark the votes for filing. So somebody needs to call the roll and see who approves of these changes and who doesn't.
Okay. Sue Brawley. Tim Lingerfeld.
Approved.
Galen Northcutt.
Approved.
Jay Kaufman.
Approved.
Done.
And I would like to thank everyone for attending this public hearing, and more importantly, appreciate all your comments and interaction through the course of the public hearing. And we sincerely hope that the document drafted will proceed on in its path and will become law, and we'll be able to live under those standards. And if it's all right with you, we're right at about 11 o'clock. Knowing that the next public hearing may be a little bit more lengthy potentially, I would like to respectfully request that we break for lunch and then come back and start afresh. Anyone want us to time we start?
Let's say our starting time has been published at 1 o'clock for the next hearing to start, right?
No, both of them were published at 9.
At both of them? Okay, I
Yes.
saw 9 on both, but
Yeah,
I
both
thought...
published at 9.
I don't think anybody contemplated doing them both one after the other, but we didn't.
Here, we might as well do them, yeah.
Do we want to say 12:30?
12:30.
Is that fine with everyone? And I'm sure some of the our public that's here, our residents, will be here too. So is 12:30 fine? Okay. All right. We'll reconvene at 12:30 for the next public hearing. Okay. It's now 12:36. I hope everyone had a good lunch and a nice walk, and we're now ready to continue our second phase of our public hearing today, and that will be on continuing education, and I'll turn it over to our attorney, Mr. Herndon.
Okay. Did we put a new sign-up sheet? This rulemaking hearing is called to order. My name is Robert Herndon. I serve as attorney for the Tennessee State Board of Examiners for Land Surveyors. Would the agency representatives who are present introduce themselves for the record?
Sue Brawley, public member.
Tim Lingerfeld, member from East Tennessee.
Galen Northcutt, Middle Grand Division.
Jay Kaufman, representing the West Division.
Donna Mulder, Administrative Director of the Tennessee Land Surveyors Board.
Lavers, Executive Director.
It is Thursday, October 24, 2013. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 in Conference Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee. The purpose of this rulemaking hearing is to solicit comments on rules the Board of Examiners for Land Surveyors is proposing to update certain continuing education requirements. The Board of Examiners for Land Surveyors is proposing these rule amendments because the Board has identified the need to update administrative practices regarding the above in order to strengthen the expertise of the professionals it oversees and to better protect the public health, safety, and welfare. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State. Notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, by the end of which time will be the effective date. Those members of the public wishing to speak should sign up at the table at the front of the room, and only those who have signed will be permitted to speak. The notice of rulemaking hearing included the entire text of the proposed rules and was filed with the Secretary of State as published in its Administrative Register website on July 9th, 2013. Ms. Smolder, what additional notice was given to the affected individuals or groups?
They were emailed out to all the licensees via the state's Notify program.
The agency hears public comments on the proposed rules. I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I'll read the substance of the proposed rules into the record. Substance of proposed rules, Chapter 0820-05, Continuing Education, Amendments. Rule 0820-05-.02, Definitions, is amended by deleting the text of the rule in its entirety and substituting instead the following so that it is amended. The rule shall read: 1. Active means a registered land surveyor who has complied with the continuing education requirements prescribed herein. Board means the Tennessee State Board of Examiners for Land Surveyors. Inactive means a registered land surveyor who has obtained an active status from the board pursuant to Rule 0820-05-.06 and is not required to comply with the continuing education requirements prescribed herein. An inactive registrant may not engage in the practice of land surveying in the state of Tennessee. 4. Professional Development Hour, PDH, means an hour of continuing education found acceptable by the board. 5. Retired means a registered land surveyor who has obtained retired status from the board pursuant to TCA 62-18-128 and is not required to comply with the continuing education requirements prescribed herein. A retired registrant may not engage in the practice of land surveying in the state of Tennessee. 6. Ethics Business-Related Course or Activity A qualifying course or activity with content areas related to the awareness of ethical concerns and conflicts, an enhanced familiarity with the codes of conduct, an understanding of standards of practice or care, project management and risk assessment management, or other similar topics aimed at maintaining, improving, or expanding the skill set and knowledge to the licensee's field and methods of practice. 7. Continuing Education Unit, CEU unit, of credit customarily used for continuing education courses. One continuing education unit equals 10 hours of class in an approved continuing education course. 8. College unit, semester, quarter, hour credit for course and ABET approved programs or other related college courses approved in accordance with subsection E of this section. Rule 0820-05-.03 Basic Requirements is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Number 1. Every licensee is required to obtain the equivalent of 30 PDHs per biennial renewal period. These PDHs may be obtained any time during the applicable renewal period. A minimum of 4 PDHs shall be earned by successfully completing a course or activity that has content focused on surveying ethics and standards of practice. If a licensee exceeds the biennial requirement in any renewal period, a maximum of 15 PDHs may be carried forward to the subsequent renewal period. PDHs may be earned as follows. 1. Successful completion of college courses. 2. Successful completion of continuing education courses. 3. Presenting or attending qualifying seminars, in-house courses, workshops, or professional or technical presentations made at meetings, conventions, or conferences. 4. Teaching or instructing in 1 through 3 above. 5. Authoring published papers, articles, books, or accepted licensing examination items. 6. Active participation in professional or technical societies. 7. Receiving a patent. Or 8. active participation in educational outreach activities pertaining to professional licensure or the surveying profession which involve K through 12 or higher education students. Paragraph 2. A registrant seeking biennial renewal of active registration must, as a prerequisite to renewal, submit satisfactory evidence to the board of having obtained 30 PDHs during the 2-year period immediately preceding application for renewal. Carryover hours not exceeding 15 hours from the next preceding renewal cycle may be included. Paragraph 3. A new registrant is not required to satisfy the continuing education requirements prescribed in this chapter as a prerequisite for the initial 1-year period of active registration. However, a new registrant is required to obtain continuing education requirements for application toward the 2nd year of the initial licensing period, if initial licensure includes 2 years. Rule 0820-05-.04 conversion table was amended by deleting the text of the rule in its entirety and substituting instead the following, so that as amended, the rule shall read. Paragraph 1. Conversion of other units of credit to PDHs is as follows. A. 1 college or unit semester hour is equal to 45 PDH. B. 1 college or unit quarter hour, 30 PDH. C. 1 continuing education unit, 10 PDH. D. 1 hour of professional development and coursework, seminars, or professional or technical presentations made at meetings, conventions, or conferences, 1 PDH. E. Teaching any of A through D above, PDH value times 2. Teaching credit shall only be valid for the first offering or presentation. Full-time faculty may not claim teaching credit associated with regular duties of employment. F. Publications. Paragraph 1. Each published peer-reviewed paper or book in the registrant's area of professional practice, 10 PDH. 2. Each published paper or article other than F1 above in the registrant's area of professional practice, 5 PDH. Paragraph G. Active participation in professional and technical societies, 2 PDH. H. Each patent obtained, 10 PDH. I. 1 hour of outreach activities, 1 PDH, not to exceed 3 PDH. Rule 0820-05-.05 types of acceptable continuing education is amended by deleting the text of the rule in its entirety and substituting instead the following, so that as amended the rule shall read. Paragraph 1. Continuing education activities for which credit may be given by the board include college and university courses which are awarded continuing education credits, or continuing education units, CEUs, and those portions of technical meetings, seminars, tutorials, short courses, and correspondence courses that are related to practice of land surveying. Paragraph 2. The board will grant credit for only such continuing education activities that satisfy the following criteria. A. There is clear purpose and objectivity for each activity. B. The content of each presentation is well organized and presented in a sequential manner. C. There is evidence of pre-planning which should include the opportunity for input by the target group to be served. D. The presentation will be made by persons who are well qualified by reason of education or experience. And E. There is provision for individual participant registration, which will include information required for record keeping and reporting. Paragraph 3. The board will grant no credit to a registrant for a course, technical meeting, seminar, or tutorial repeated by the registrant within 3 years if credit was originally granted, unless, in the board's opinion, there is a substantial change in the content of such course, technical meeting, seminar, or tutorial of the complexity of the subject matter warrants of additional credit. Paragraph 4. All activities submitted to the board for continuing education credit are subject to approval by the board. Rule 0820-05-.06 inactive registrants is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Paragraph 1. A registered land surveyor may request in writing to be placed on the board's inactive or retired roll, thereby obtaining inactive or retired status. 2. An inactive or retired registrant will be permitted to retain that registrant's original certificate of registration by paying the fee for registration without submitting proof of complying with the continuing education requirements prescribed herein. 3. An inactive or retired registrant may not engage in the practice of land surveying in the state of Tennessee. Any practice or offer to practice land surveying in the state of Tennessee by an inactive or retired registrant shall constitute misconduct for the purposes of Tennessee Code Annotated Section 6218-116. Rule 0820-05-.07. Reinstatement to active registration is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Paragraph 1. An inactive or retired registrant seeking to reinstate an active registration of 1 year or more must submit a request in writing to the board with a fee of $25 and must satisfy one of the following requirements. A. Satisfaction of the biennial PDH requirement multiplied by the number of years of inactive or retired status up to a maximum of 30 PDHs, or B. Successful completion of the Tennessee State Specific Land Surveying Examination within 1 year immediately prior to application for reinstatement. Paragraph 2. An inactive or retired registrant seeking to reinstate an inactive or retired registration of less than 2 years must meet the biennial PDH requirement. Rule 0820-05-.08 Noncompliance is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Unless a request for inactive or retired status is made, any registrant failing to furnish the required continuing education form properly completed and signed shall not be granted renewal of registration by the board and shall lose the right to practice land surveying in the state of Tennessee upon the expiration of registration. Rule 0820-05-.09 Hardships is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Paragraph 1. Notwithstanding any other provision of this chapter to the contrary, the board may exempt a registrant from complying with all or part of the continuing education requirements for a given year in the following cases. A registrant affected by physical disability, illness, or other extenuating circumstances as reviewed and approved by the board, providing that adequate supporting documentation is furnished to the board, or B. A non-career military registrant serving on active duty in the Armed Forces of the United States for a period of 120 consecutive days in a calendar year, provided that the adequate supporting documentation is furnished to the board. C. Those who are 65 years of age or older, who also have 25 or more years of active registration, provided that adequate supporting documentation is provided to the board. Rule 0820-05-.10 Reports and Records is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Paragraph 1. Each registrant shall report on a form provided by the board the continuing education activities undertaken during the preceding year. 2. The registrant shall maintain a file on which records of the activities are kept, including dates, subjects, duration of programs, printed program schedules, registration receipts or other proof of participation, and other appropriate documentation for a period of 3 years after the date of the program or activity. Rule 0820-05-.12 Approval of programs is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Paragraph 1. Approval of any program may be granted to a sponsoring organization or individual if the following information is submitted to the board. A. Instructors and their qualifications, and B. Synopsis of course material. 2. No sponsor may provide any continuing education courses without prior approval from the board. 3. Upon completion of the approved course, the sponsor shall submit to the board the record of attendees as provided in Rule 0820-05-11 above, and time, place, and schedule of activities. 4. The board may appoint an advisory committee to assist the board in evaluating continuing education programs to determine the allowable credit to be awarded. Rule 0820-05-.14 comity is amended by deleting the text of the rule in its entirety and substituting instead the following so that as amended the rule shall read. Paragraph 1. The board will deem a registrant to have met the continuing education requirements provided herein if such registrant, when making submission of continuing education toward renewal of Tennessee registration, certifies in writing the following. A. The registrant resides in another state or territory which has been recognized by the Tennessee Board and shall satisfy all continuing education requirements for renewal in Tennessee. Right, now is the comment period. The first thing I'm going to do is read into the record the written comments that was submitted by the Tennessee Association of Professional Surveyors, and we'll let the board respond to this written comment. Dear members of the board, the Tennessee Association of Professional Surveyors held its most recent Board of Directors meeting on Saturday, September 28, 2013. During the course of its regular business, the floor was open for review and comments on the subjects of the upcoming public rulemaking hearing scheduled for October 24, 2013. In all instances, the members of the Board of Directors were in full agreement on the following topics and the proposed resolutions thereof. On the first subject of the rulemaking hearing, Chapter 0820-05 Continuing Education, there was much discussion on the conflicting criteria for the pre-approval of courses. We struck upon a truly novel idea: abolish the entire pre-approval process. Board rules clearly state the type of acceptable continuing education. A surveyor is a professional capable of interpreting this rule. Instead of expending time and effort on pre-approval, we feel the board would best be served by placing the emphasis on an auditing process. Full responsibility for record keeping and archiving would shift to the individual registrant and away from the Board of Examiners and staff. Recently, a survey was conducted concerning the continuing education policies of 27 randomly selected states. Of the 27 total, only 6 have a pre-approval requirement. 16 of the 27 have no pre-approval process. The remaining states either had no mandatory CE requirement or had limited pre-approval. 5 of our 7 neighboring states do not pre-approve any continuing education courses. Attached, please find our recommended revisions to reflect these suggestions. As a second proposal on the subject of the rulemaking hearing, Chapter 0820-5 Continuing Education, there was discussion regarding the possibility of the Board of Examiners to begin discussions with adjoining states regarding reciprocal agreements with adjoining states for the purpose of continuing education. And then we turn suggested changes. Suggested changes to Rule 0820-05-.10 Report and Records. The responsibility of maintaining records to be used to support credits claimed is the responsibility of the licensee. Records required include, but not limited to, a log showing the type of activity claimed, sponsoring organization, location, duration, instructor's or speaker's name, and PDH credits earned. attendance verification records in the form of completion certificates or other documents supporting evidence of attendance. These records must be maintained for 3 years. Copies may be requested by the board for audit verification purposes. Each registrant shall report on a form provided by the board the continuing education activities undertaken during the preceding year. Much of this was found in the Mississippi Board 2012 revisions of their continuing education policy. Then recommended changes to Rule 0820-05-.12, approval of programs. Courses will not be pre-approved by the board. The board has final authority regarding approval of courses, classes, seminars, meetings, and all other method of satisfying the requirements of this chapter, and the number of PDHs allocated to each course, class, seminar, meeting, and any other method of satisfying the requirements of this chapter. Partially from State of Georgia policy. Next suggestion, delete current 0820-05-.12 is now proposed, and insertion of a new board rule as follows. Rule 0820-05-.12 audits. Proposed language is, the board may conduct random audits each year of reporting continuing education credit after each license renewal period according to the following procedures. The population to be audited for continuing education requirement compliance shall consist of those licensees who are renewing their license with the board and who are not claiming and qualifies from an exemption under 0820-05-.09 hardships and exemptions. The sample for the audit should be chosen not less than 180 days after the renewal period is ended. The sample size for each audit should be 2% of the population chosen at random. Each licensee chosen for audit shall provide within 30 days in a form supplied by the board a log of continuing education obtained during the previous licensing period with supporting documents attached according to the requirements under 0820-05-.10 reports and records. The board may appoint an audit advisory committee to assist the board in evaluating continuing education programs to determine the allowable credits to be granted each auditee by assigned number and not by name. Those auditees failing to respond or unable to verify their claims of continuing education or unable to satisfy the continuing education requirement by reporting less than the required number of hours should be placed on probationary status and notified of that status. The auditees shall have 6 months from the renewal dates to respond and provide proof of their claims of continuing education, or his or her license will be placed in an inactive status. Licensees placed on inactive status may return to active status as provided for at 0820-05-.06 inactive and retired registrants, partially from Tennessee, Georgia, Alabama, and Mississippi. Okay, that's the written response that the board needs to address first.
Not that I know of.
Well, no real comment off the top of my head here. After having reviewed those are quite a bit of suggested changes there from the professional society. Certainly respect the point of view there of where they're going. I did notice one of the comments, if I understood it correctly, was that essentially go to an audit-based system that many of our neighboring states have. Offhand, one I can think of is Mississippi, as I was randomly selected one time for an audit. It's more of a professional / honor basis is the way I look at it in that particular state, and no disrespect to Mississippi whatsoever in the way that they handle it. It certainly has a valid point, certainly one for discussion. I don't know that it at this particular moment in time that it would be something effective or something that we could put into system right now within the state of Tennessee, but it certainly holds some merit, and I certainly do honor the suggestion to it. Anyone else?
Well, I guess I get to be the historian. because we've worked on these for a pretty good while. Just for the public and for TAPS in response, we looked at several states' continuing education requirements besides our own, one of which was Georgia, one of which was Kentucky, another was North Carolina, another was Alabama, another was Mississippi. So in our deliberations and discussions, we looked at how they did things, and we considered how they did things. I can tell you that from the standpoint of how Tennessee is looked at as a member board with NCWS, is we're looked at very highly when it comes to continuing education. Primarily because of policy that was created in 2009 relative to how we manage the continuing education process for credit and review. And I felt it very important to continue that level of standard. And I think that these rules reflect the board's kind of consensus as to maintaining that standard. I did a little quick arithmetic on the last item that was in this letter about the 2% audit. Well, currently we do a 100% audit, and for the true conforming professional, which are I'm certainly individuals in this room, it's not an issue at all. But we have all kinds of scenarios, issues. Renewals are coming up at the end of December, and I can assure each and every one of you sitting here that in our next board meeting, which will be in January of next year, that we will have a reasonable number of requests, questions, etc. about PDHs in some form or fashion for someone's continuing education. And this rule has been in place since, I think, 1994. So, and these are not people that are first-timers that are just, they just had their license the second year now and they're sending in their first information. These are people that have been there for many, many years, and Donna can tell you more stories about it than I can. But we regularly have that situation, and we shouldn't, because I think they're basically pretty clear right now as they're written for the most part. But we're trying to clarify them even more and get a little tighter grip on that, because I'm a very big proponent of continuing education myself, and I know this board is, because I think it makes all of us better professionals. But the one area I was questioning on the audit side here was it says 2%. If my arithmetic is right, if we have 1,171 licensees, as was reported yesterday in Donna's report, that would only mean that 23 individuals will be audited in a given period of time. In other words, that would be on a biannual basis, 23 people, because of the way we submit our PDHs for our continuing education. I certainly couldn't favor that, because that's going from all to virtually none. But that's a personal opinion there. But I think the spirit and intent of where we're going with these rules is very sound. But the most important thing I want to say to the association is everything on these 2 pages that Mr. Hernan read relative to this letter has been reviewed at some point in time in our considerations. And as you've seen from the previous public hearing, if the board so desires, as we get to those particular sections, to incorporate or modify or whatever, we may do so today. But at this point in time, I just want to kind of relate to you that, hey, yeah, we have looked at these, and we looked at them in pretty good length, because we worked on continuing education virtually, I guess, the whole time you've been on the board.
For 2 years.
Yeah, a good 2 years. Because the process itself takes some time, and then we have to do a lot of work on it and so forth. So I guess that would be my response to that, Rob.
Mr. Creddy, would you like to comment?
Well, I just feel strongly that I don't know. There's a lot to say. I don't feel like the pre-approval thing is working 100%. I don't think it's working 80%. I'm on the advisory committee, and we've had we're one guy shy, and we have been for quite a period of time. And I had a envelope I was going to bring up here. It weighs 16 pounds, and that's, I think, what I've gotten this year to review. And there's like two aspects here. One, I strongly believe that we are professionals and that we should police ourselves. I like the idea of the audit process going to it. Pre-approval process, if we stick with it, then we're going to need more guidance than what we have now. We got all kinds of, it's like the deal with the 4 hours. Well, all of a sudden, everybody became a correspondence course. It's no longer a computer course. And it's real muddy, and then there's some things, the way it's written, well, you've taken care of a lot of it with the new proposed rule changes. But I'm conflicted. There's two issues. I would like to go to the audit process if y'all would consider that, and if we stick with pre-approval process, this probably doesn't need to be in this meeting, but we do need some better guidance than what we have now.
Let me address that just a second, Bart, if I may. To give you an example, there are, I don't remember the number, I counted in here one day, I want to say 28 states that currently accept NCAAS sponsor approval or vendor approval. Now, all that amounts to is the sponsor or vendor submits an application to NCAAS for the courses that they intend to provide to professionals, surveyors, and they do engineers too, across the United States. And basically NCAAS charges them a fee. So I want you to know we looked at that. We also looked at the state of North Carolina. They basically do pretty much the same thing. They have $100 per course one-time fee. So as you mentioned in here, that it is partial approval. And so we looked at that scenario, but we're somewhat, at this point in time, hem-strapped, I guess you would call it, relative to, creating fees of that nature and things of that situation, because of the way that our statutes are. We're only allowed to charge fees for certain things and so forth and so on. And I'll let Galen speak to what we've been addressing about the advisory committee that you serve on.
Mark, yesterday in our meeting with the assistant commissioner, touched on the review process and laborious effort that is put into by the three guys that have been on this. Ask about charging a fee to the vendors, that when they submit courses, we have a fee that we charge that vendor, a pretty hefty fee that keeps out the trash stuff and gives us the good stuff as far as the type of course that we're going to get. But that fee is then passed on to the advisory committee, whoever is doing review on a suggestion and a request, and they're going to look into this thing, because there are other states that do charge a fee. North Carolina, as just mentioned, and that cuts down, at least we feel like, that would cut down on the garbage type courses, because you get a course that comes in and you say, what color rod should I use, or hey, we're going to explain to you how good it is to use our particular type of scenario out in the field, that kind of thing. Junk. You're not getting any meat and potatoes out of these type of courses, and so we have requested that we be allowed to charge a fee, the vendors a fee, to submit courses to the advisory committee or to the board. So we give to the advisory committee, let them review good courses. You can kick out which one.
That would have to be a legislative thing.
Well, I understand that, yeah. and we have been talking about that very thing. So that's what we have requested.
May I address that? This came up in the TAPS meeting, that suggestion, and I kind of look at it just opposite of the way you're looking at it, Mr. Northcutt. A fee would keep me from presenting courses, and I've only charged my whole career for one course, and that was something I did for Half Moon, and they just paid me. I do all my courses for free. Well, I'd be paying a fee, and what I think would happen would be the big boys like McKissick and Red Vector and all of them, they would have the money to pay that fee, where I wouldn't have the money to pay the fee for numerous courses that I do a lot of study and put a lot of time into, to be able to present for free to chapters and to individuals.
I understand where you're coming from that aspect, because we do think that the professional organization has very qualified people that can present courses. Question about having courses presented by the professional society as far as our in-state folks. We were just talking about outside. Really worth considering what we would do with that.
Thank you.
Just one quick comment, Steve Ward. One of the things I've heard on the local level and seen on the local level is the time that it takes to get the pre-approval. One of our local, City of Knoxville, does a symposium every other year or so where they go through all of their regulations to help surveyors and engineers be up on their standards. Very worthwhile program. Oftentimes we don't know until the very last minute if we're going to be able to get credit as surveyors because it takes so long. And I understand that you all are by no means a shot at anybody on the review committee, because I understand the effort that's involved there. But that's what we see as a local chapter when we try and do in-house continuing education. It takes such a long lead time to get that material in and approved and so forth that it's almost unworkable on our level to get courses pre-approved. It ends up killing the initiative to get it done.
Since I assume, have you submitted for some courses for the chapter or something
I
of that nature?
I have not personally. We have Dr. Freeland who teaches at UT, who has sort of speared that effort for us locally.
My question to you or to any of you as far as that goes, Bart, whoever, would be, what is the cumbersomeness of the current situation that we have in submitting for course approval? It was my understanding that, one, there's a form on the website, and two, you fill that form out and you submit it, and three, if I understand our rules correctly, we had up to 90 days basically to approve it, which if it's a professional situation, it shouldn't take that long to approve. Now from there, I don't know, maybe Donna can clarify that as far as what's happening there.
Well, when I get the recommendation, then we approve them. But if I don't get the recommendation within 90 days, the course is automatically approved according to the rules as they are now.
Right. So
that's what
are
I
the
have to wait on.
recommendations slow, or?
Yeah, sometimes I get them really quick, sometimes I get them really slow.
Mr.
I'll
Chairman.
address that. I'm sorry.
Alan Crawford. I did not have a heartfelt position on this matter in general that TAPS presented, but I do have a heartfelt position in particular when it comes to the presenters of some of these courses. And I personally, as a TAPS member and as an individual, both would much rather encourage persons like Bart Craddy to come give courses. Well-heeled corporate vendors. So I do think that type of instruction is more valuable. I think it's more interesting, and it comes from a truly land surveying perspective.
It sounds to me that our board, and I'm certainly take that very personal, our board has been remiss, and we have not monitored that situation as closely as we should have to make that process for, as Galen phrased them, our in-state folks that's doing things simpler than what it has been. So, I apologize to that effect, but and I certainly will make a promise that we will look into that and see if there's any way that we can clean it up, expedite it, change that part of the system or whatever it is, irrespective of what we end up today with these new rules. But we will look into that.
I'll just here's my personal experience with that. When I get one and I open it and I respond to it right that minute, she gets it that email that minute. When I get a stack of them this big, they go over here, and I can't make myself grab that stack and start going through one by one by one by one by one. And that's the ones that get the 90-day approval. And a lot of times, and I apologize to the board for doing this, but a lot of times they're the ones that shouldn't.
Because we have asked you to volunteer to take on a task that has no pay and has an unknown time requirement, and we appreciate what you do.
Well, the bad thing is, a lot of times those are the courses that shouldn't be approved, and they get approved by the 90-day period. That's what I'm apologizing for.
Apologize. We have a flaw in the system. We need to do a better job.
I want to stick with the pre-approval process. We should maybe do a workshop or something.
We appreciate those comments. Those are the things that we need to know. If something's broke, we can't fix it if we don't know it's broke.
All right, Mr. Tessar.
I do have one question here. In the conversion table, it was mentioned about...
I'm sorry. Please tell your name for...
Okay, I'm sorry. Leonard Tussar. In the section 0504, the conversion table, it's been discussed about online courses or correspondence courses. I don't see anything listed there with regards to that particular type of PDH. Was that just omitted by chance, or is it the fact that those are not going to be accepted anymore?
Straight answer, they're not going to be accepted anymore.
I don't have a dog in the hunt, but
Yeah.
I noticed it wasn't there, and I noticed, I know several other professionals that do a substantial amount of, whatever was previously required. I think was 7.5. They allowed half of your CE,
Right.
Your PDHs to be by online or quote unquote correspondence courses. So those are no longer going to be acceptable.
Why?
Well, basically, and maybe Bart can help me with this a little bit too, but the internet courses that we have seen at the board are all over the place. I mean, they're from an 8-hour course that you can print the test out and do it in 15 minutes to an 8-hour course that you really got to pay attention and work it, and you get some benefit out of it. So they're just all over the place, and we have precedents in the state of Tennessee with the attorney profession. Their continuing education is all what we call seat time, and that's basically what this is going to, is seat time. So that's kind of the premise behind that, because it's kind of like buying a car. There's 150 different models out there, and you may get one that's a lemon, and it's the most expensive one out there. And that's kind of what we've been seeing with the internet courses. They're just all over the place. Just not a level of consistency, because I don't think anybody that I've reviewed their state rules relative to continuing education has any specific way of creating criteria and structure for internet courses. I think it's totally left up to the vendor, and I get the solicitations on email just like all of y'all do, and being on the board, I go look at them. I mean, I go do seat time for all my hours, but I go look at those things and see what they're offering and what's there, and I'm appalled by what I get. Maybe I just get all the bad ones, but I do see some good ones every now and then. But for the most part, they're not. all I can say about that is it's an easy way out for the guy that waits till December the 20th to want to get his hours.
One thing that you might want to consider are webinars, because attorneys are allowed to do webinars, but that's something where you're actually participating via the internet. It's not an online course that you view. You actually have to be there and participate in it. You may want to consider allowing where it says seminars to also include webinars, which would be, you wouldn't have to physically be there, but you are participating via electronic media, like NCAAS is talking about doing with their meetings.
You know, and I realize it's kind of counterproductive in a way. We just sat here 2 hours ago and we talked about computer-generated seals and signatures, and now we're talking about eliminating something that comes across the computer. But again, the relativeness of it is what it is. It's quality. You know, are we getting the quality? And yes, Mr. Crawford, you're exactly correct. We have had presenters at conventions, meetings, and so forth that were not exactly what we had hoped for. But sometimes you just don't know. You know, they present a course syllabus, and you got a slot, you fill that slot, and sometimes it doesn't work out. You just don't know. You know, most of the time, the big boys, you sort of know what you're going to get with them. So that does happen too, and we understand that.
If I may, Alan Crawford again. I don't have a dog in this hunt either. As a matter of fact, this is coming from a person who told Marty McClure a couple of years ago, who was complaining to me on the telephone about not being able to get as much credit for these online courses as he would like. And how come TAP's isn't doing a better job of representing us? And I said, Marty, we did that just to get you to come back to the convention. Now, having said that, I do wonder where technology's headed, and you know, if I thought that this policy was for a term, then I think maybe we might be able to express to our members that they could live with it for a term. But given the quality of the potential for online courses, I sort of hate to see the door closed completely on that sort of study, because I do know people who are able to retain information very well in that environment.
I don't feel like that this eliminates online courses, with my definition of an online course being relative to a college, like distance learning, things of that nature. I don't think that eliminates that. I think it eliminates just the pure vendor-solicited internet course. Such as, I know you remember way back when you used to could order a continuing education course, and it would come on a VCR tape, and you had to chuck it into the TV and sit in front of it and watch it, before they did it on diskettes and all that kind of stuff. So, you know, I know you remember those days. And some of that stuff was the same product. I mean, you know, I'm sure Bart remembers that too. You know, it was the same stuff. You could, you know, just print the test and send it in, you know.
Consider inserting webinar into subparagraph D on the conversion table. Under Rule 4.1D, 1 hour professional development coursework, seminar, webinar, or professional or technical presentations. Just so it would be bookmarked in our rules so that the board could be able to accept it.
Let me ask this question also. If you included it there, Mr. Herney, would you not want to include it in Rule .03, Paragraph 1, Line 3?
Wherever it's appropriate, if you want to do that.
Those, because those work hand in hand. They're a pair.
Okay. And we'll come back to that after public comments are concluded.
I'll make a note. I'll make a note of that, and I think that that's something that's very workable.
Because like our public members of the public have been saying, it's getting into every aspect of professional practice, and attorneys are some of the last people to change, and they're starting to use them. Mr.
One other comment.
Yes.
Stephen Ward, just a real quick question on item G under the conversion table, the active participation in professional and technical societies. when we went through these at the Middle East chapter, there was some question as to what sort of documentation was going.
Okay.
Does that constitute attendance at local meetings on a regular basis?
Let me say that in line 6 above in the previous section, the .03, there was a sentence that was left out that's very important, and it will help answer your question that I'm going to add into when we get to, but I'm going to read that sentence to you just so that I can answer your question. That sentence says, limited to two PDHs per organization, requires that a registrant serve as an officer and or actively participate in a committee of the organization.
It's just designed.
So in other words, just because you belong to TAPS does not mean you're going to get 2 PDHs.
You can't be passive member. You have to.
Right.
That was
You
the
have to be
question.
an
If they showed up
active
for
member.
dinner every month,
Yes.
did they
No.
get their 2
No.
PDHs? And
Right.
we thought that was probably not the case.
No, that's not the case. And there was a sentence that was left out there when this document was printed. And
Thank you.
I was going to see if
would,
it was going to get added.
that would add great clarification.
Mr. Tussar?
Yeah, one other thing with regards to registrants that are registered in other states, and they do their continuing education for that state, would those continuing education units be considered acceptable to Tennessee if they were accepted by that state's board?
Okay. That's a very good question, and let me answer it as best I can. Let's use Kentucky for an example. It's a state very close to us. Kentucky requires 8 PDHs for their continuing education. If you were licensed in Kentucky and resided in Kentucky, but also were licensed in Tennessee, okay, that's the criteria we'll discuss. You would submit your PDHs from Kentucky, okay, because you're an out-of-state resident. You would get credit for those 8 PDHs, okay, but you would still be responsible for, in this case, for discussion right now, 7 more additional PDHs, okay. All right, now let me change direction. Let's go over here and say that Bart is licensed in North Carolina, okay, and lives in North Carolina. North Carolina requires 15 PDHs, okay. When he submits his 15 PDHs for his Tennessee license, it reciprocates 100%. Just like your 8 did, but you only had 8.
Right.
But he had
Right.
15, so he
Right.
didn't have to take any more.
Right.
But because you only had 8, you have to.
Oh, I understand. Okay.
And each state that is around us have a different scenario. Georgia's 7.5, and so forth. Each one of them has, Virginia's 8 per year or 16 per biennial, and so forth.
So then the registrants that are multi-licensed, don't have to take their 8 and another 30 here because they would get, or another 15
Right.
or whatever
Yes,
the
sir.
number is.
I just
would
used
be-
a 1-year example, yes.
Yeah, okay.
Don't require pre-approval.
Those outside of the state do not require pre-approval because those fall under the comedy scenario.
I think they'd still be subject to board approval, though. You can submit them, but
Yeah, if we saw
be
something
discretionary.
that you took, underwater snorkeling to shoot sharks or
It's
something.
because one state will
They took
accept
it, well, we could,
Work credit here. What I was going to point out would be I just 2 Saturdays ago or something I took minimum technical standards for Georgia. I don't expect you to accept
No,
it.
sir, and we would not.
Yeah.
We would not, and I'll speak to that in a minute too. But Jay has a comment.
No, I was
think-
agreeing. I was agreeing
Oh, okay.
that would be.
Yeah, that's the one that, like in Kentucky, for example, it's required every 4 years. Georgia's 5, if I remember correctly.
6 hours every 5 years.
Yeah. So those situations, because the minimum technical standards of Georgia, they somewhat relate to Tennessee, but they don't. They don't. I mean, it's a whole nother ballgame. Now, one thing that has not been mentioned that I want to bring up, and it'll appear in our discussion as we go along, just for your all's edification. Because of and to go back to Leonard's question, because of the elimination of the internet courses, we have looked at 2 things. One is changing the annual and biennial, that's a tough word for me for some reason, requirement to 12 and 24 hours because of it basically going to seat time. It's kind of a little trade-off for eliminating that internet stuff. And also included in that, and you heard it read, Mr. Herndon read it, is we're looking at adding this asimilar course that Bart just mentioned he took in Georgia on ethics and standards of a 4-hour nature that would be required by the registrant to have. And the reason that the board felt strongly about that was primarily because of our complaint history. If you look at our complaint history, the two primary things that we see more of, and Mr. Hernan can correct me, than anything, are communication issues, which are ethical in my mind, and standards issues, which are technical in my mind. So the board felt like that neighboring states were doing it with some level of success, and it's not something that has to happen every year. And we felt like that it would be positive in the continuing education process to add this course, and this type of course, so that it would help bring along these individuals that we've been getting some of these complaints on, and help better and truly better their profession by making sure that every registrant understands the standards and understands the ethics. Because, all of you remember when, we used to get this book right here. It was red, and it was green, and it was blue. We used to get this, and everybody's got one laying on their desk in the office and so forth. Well, only about 40% of it's any good now because some of the things have changed.
I still have a gold one.
You got a gold one? I don't know if I got a gold one or not. But everybody used to get those in the envelope, and they would put them on their desk, and most people would look at them, and some people would look at them occasionally, and some people never opened the envelope. But that doesn't happen anymore. Just like our new standards of practice, you got to go on our internet website and go on there and look at them and leaf through them and read them, or print them out and read them. Well, there's less people that will do that than will pick that up. I realize I'm a little old-fashioned about that, and that's what will happen with these two public hearings that we're doing today. When those are officially changed, they'll go on that website. People will be notified, hey, we got to change. But even if we make an effort to send out just that document, it still doesn't solve that problem. So we feel like that it's important that we have that course also, so that not the true professional, not the guy that does what they're supposed to do, but it's the guys that are on the opposite side of that spectrum and somewhere in between that we have these issues with when complaints are filed. So we're trying to help make it better across the board for everybody.
Bart Craddy. The one I went to in Georgia, it was a small chapter meeting. There were like 10 guys there, and like the moderator, he said, "What's funny about these is the people that here don't need to be here. The people that should be here aren't here." But to a man, everybody in there had at least 2 items come up in that technical standards that they had been doing wrong. So, no matter how conscientious we are, you'll find out you're doing a lot of things wrong.
I just want to give you a little bit more background of where we're kind of coming from with these and why. We're trying to shape these in a new way, to be more progressive, more modern, but at the same token, we still have some of the old problems, and we still got to embrace those. And, if we get those embraced, then down the road a few years, maybe we look at them again and we get them to another level,
Last public member is Mr. Cleveland. If you'd have some comments.
Jimmy Cleveland. Like I said, our proposals here were kind of a compilation of a lot of discussion and whatnot at our last meeting. I'm kind of got mixed feelings on the continued education front. I recently attended my first out-of-state conference, and while it was Missouri specific, there were a couple of courses there that would be excellent for any professional across the state. One of them being analysis of surveying errors and things like that, where the standard deviation, talking about some of the analyzing the data, would be great for any of us sitting in this room that are licensed. And another one was kind of a maps and records and analysis type class. It was an all-day 8-hour class. It would have been great for any of us to sit here. But however, I would love to be able to have those just in the bank per se. If something were to happen, they weren't pre-approved in Tennessee, so I couldn't use them. But I mean, that's neither here nor there. for people in that aspect that are licensed in multiple states, the audit process would be beneficial because they could use those quality courses in that, whereas the minimum standards, course for. And then I've also got friends all across the state, and two friends are serve on the advisory committee now, and they're just, and I've heard stories of them being just totally overwhelmed with the bulk of information, and my heart goes out to them because it's a very laborious process to go through those and have to weed through the ones that are good and the ones that are close to John. So it's got mixed emotions. I mean, I would like to, if for those, one of the proposals that came out of one of the chapters was the reciprocity agreements between Tennessee and, say, Kentucky or Virginia or Mississippi or whatever, because there are some quality courses there that even though somebody may live in Tennessee but may go to that neighboring state to take a quality course, it'd be nice that there was some way we could incorporate those quality courses to count towards, credit in Tennessee. I would really like to see that happen. I think it might make it a little easier for some of our registrants that are licensed in multiple states to, get a little more credit per se for investing that time, because.
I think that's a great comment. Tennessee is one of only 2 states in the United States that's surrounded by 8 other states. So we have a tremendous amount of dealings with other states and their surveyors. And I am not opposed to that whatsoever when we get to that part of that, on the comedy part of creating some language to add into what we've got for that very reason of being able to add a quality course from somewhere else. I don't have any issue with that. Very good remark.
Okay, that concludes our public comments. So now it's time to adopt the rules, either as proposed or amended. Start here on Rule 0820-05-.02 definitions, as it was previously proposed.
Trying to write a thing for what Jimmy was talking about. I'm fine with the definitions, Mr. Herndon.
You're all good.
Okay, Rule 0820-05-.03 was proposed as written.
Webinar somewhere in there because it's also over in 04.
We'll look at these paragraphs.
Let's talk about paragraph 1 first, if we can. I would like to recommend that we change the biennial PDHs to 24 instead of 30. So I'm going to leave that for discussion.
I'd be curious to know if TAPS has a stance on something like that, the reduction from 30 to 24 PDHs. I know this is short notice, and I don't know that you can speak for the whole body right now without a proper discussion, but that I'd be curious to know if TAPS or any of its members that are present has a particular opinion on that, because I don't know. I kind of my first question on it personally is why.
Well, let me say this, Jay. At last March's annual meeting, Galen and I met with Benny Mormon, the then president, who's now past president, and Lori Medley, and discussed this very situation with them. And I'm not going to speak for Galen, but I came away feeling that they were comfortable with it, with the change from the 30 to the 24. For a couple of reasons. One reason was that it would allow them a few more hours in their normal convention window that they utilize to be able to do some other things that they don't normally have time to do because of the time that the normal meetings and conferences for PDHs take up. Now that was what was said at that time, and Galen can reiterate what he heard.
I have to agree with Tim. That's what it was, and speaking with Benny about it, there were some concerns, perhaps part if we reduce this, but only reducing it 12 per year. You're only reducing it a 3-hour seminar time. So with that, felt like that he thought things were really good to do that, and that did allow the practitioner to do some other things and to get in to see their vendors and et cetera that are there.
And there's also one other trade-off, Jay. Having just went through the previous public hearing and seeing the questions, one of the questions that we were asked is it going to cost the registrant more money? And the trade-off there is if the internet courses are eliminated, even though they're almost dollar for dollar what you pay if you go sit down at a seminar. Some are less, some are more. Just depends on what quality you're seeking and what course you're seeking. So the reduction in the hours was going to ultimately end up being a trade-off because the registrant then would need to go someplace and sit down and do it versus sitting in their office doing it on their computer. So there could be some small cost that was to them. So with the reduction in the hour, that was kind of a trade-off for that scenario.
Yeah, and that's a valid point. I do have to respectfully disagree with the first point that you brought up, in that the changing from let's just say 15 to 12, as it would be mathematically, is more convenient for the convention and their scheduling. I just can't. I cannot put education on the same level with convenience of a convention. I can't do it, and maybe I just misunderstood it, but I just can't do that. I have an issue with that. But outside of that, not only would this be a reduction, essentially from 15 to 12, but we're also a little bit further down in this rule here, including in that what would become 12, essentially 2 in regards to ethics and standards.
That's right.
So not that that's a reduction in the overall total, but that is a reduction in the content of other educational sources that they used to have before this second part came in as a rule, ethics and standards. Not to minimize those two at all. In fact, I completely agree with ethics and standards. But I do give credit to the argument that, yes, there is, in some respect, an additional cost on the registrant in that they're losing the ability to gain their PDHs by sitting at a computer. Because although generally speaking, yes, you're right, they basically are tit for tat cost-wise, there is some cost savings in terms of you don't have to travel, time away from work. It's something you could do literally at lunch. Hotel expenses, if that's incurred, et cetera, et cetera. So I think in the big picture, yes, there is a reduction in cost in terms of obtaining PDHs based on the internet, of course, depending on the vendor and the direct cost associated with it. But I just don't know. I can honestly say I've never heard anyone complain that 15 is too many. Not that I've actively taken a poll or anything, but nobody's actually ever said to me, golly, 15 is just too many. I'm curious to know other states. I'm not licensed in Kentucky. I kind of raised an eyebrow when you said 8 was required in Kentucky. I kind of was thrown back at that, to be quite honest with you. I don't know. I just don't see the necessity behind reduction from 15 to 12, other than I certainly can't agree with the convenience factor of a convention. I can't go with that at all. But the cost, yes, that is a valid argument. But
possibly my use of the word convenience was inappropriate, but I inferred from the conversation that it would give Lori and TAPS the ability to do other things within that window. And maybe the word convenience was incorrectly stated.
May I moderate between you two gentlemen? Alan Crawford, and this goes back, this all ties in on so many levels, back to the ceasing of the internet courses. Surveyors need to get out more. And truly, if somebody's going to come to our convention and get their education, I think they are probably, whatever extra time they might spend talking to other surveyors, talking to other professionals, talking to the presenters in the hallways, I think is going to certainly make up for the reduced number of hours. The social aspect of that convention is tremendous, and I think everyone should do it. I don't suppose we could convince you to say, okay, you get the fewer hours if you come to the TAPS convention, and you have to take a greater number if you don't. But we would love that. But I do think that by denying internet courses, if you're encouraging people to get out and to visit with their fellow professionals and with some of the educators, then you've done a great service. So I think overall, you've hit a tremendous medium here.
Well, you know, my East Tennessee English isn't as real good as Jay's West Tennessee English, and I say the wrong things sometimes. But another thing that was considered in this particular section, staying in the same spirit, was the frequency of these 4 PDHs for the ethics and standards. As Bart and I had spoken before, there was different variances in when Kentucky requires them, when Georgia requires them, and so forth. And we looked at that and we bounced it around, and we really never did come to a real good consensus. And I'm certainly more than open if we want to, say that this must happen, in a 4-year window or 6-year window, whatever kind of window it is, because I understand your point where you're coming from. If that particular course is taken, it changes the dynamic of the convention based if there's only 8 other hours to get or whatever. It changes that whole dynamic. I understand that. And it's a very good point. So I just wanted to let you know, because I know you were not part of those discussions, that we never really firmed up the frequency for that course. We were hoping to get that course approved, but it really needs a frequency tied with it also. I agree.
I do want to, there's one thing I do that's just kind of gnawing at me here a little bit. I do want to make clear that there is a very distinct, this is in my view, a very distinct separation between this board, its activities, its requirements in education, and the convention that's offered by TAPS. I don't want to give the impression that it is mandated by this board or even suggested by this board that they have to, or that we accommodate these hours associated to the convention itself. I've been a big member of TAPS forever. I've been a very big supporter. I think you know that by my involvement in it. I'm still very active in it and a very big supporter. I've been to every convention I can. But I think it's clear that we need to make sure there is a very distinct and separate, a divide between these hours that are being mandated and how they obtain those hours, and that it's not even implied that we formulate these hours around that convention that TAPS offers.
Right, and I want to apologize because I just used TAPS as an example because we have a good representation, and that takes in the largest group of, probably the largest group of our licensees at one given period of time to get their continuing education. So I use them as an example. We could have very easily talked about Don Wilson giving a seminar in Pigeon Forge or whatever it is. So I do apologize, but you're 100% correct in what you said, that we are not, none of this is structured around TAPS or any other particular entity or organization.
I had to try.
It's just for the registered straight across the board.
Tim, I only say that really for those that are watching on video to make sure that that's clear and that we understand that.
Yeah. No, great comment. Thank you, Jay. Thank you very much. So I guess to continue on this item, I guess we need to make 2 decisions. One is if the board has a pleasure of changing the PDHs, and 2, if we want to create a frequency for the ethics and the standards.
My personal point of view, and y'all can certainly agree or disagree with it, is I'd like to maintain at 30. That's my personal point of view. I do agree with the requirement of the 4 PDHs to be gained by ethics and standards of practice. The frequency of 4 PDHs over the biennial, i.e. 2 years, is fine with me. I have no problem with that. My only discussion or point of contention really is the number of PDHs, but you're certainly open to not agree with that.
Doesn't bother me one way or another. I'm an advocate of the hours of ethics and standard of practice every 2 years. That's fine with me, I think.
You don't have to take any of them.
I know. I don't even take them with my insurance license. I'm sure people would want the less hours, but it's just really up to your profession.
There we go.
Comment.
There we go.
Stephen Ward, I may get burned at the stake at the next local meeting for saying this, but I personally, I don't have a problem with the 15 hours. In fact, I would hate to know how many hours I have just. In fact, one year I didn't even turn in the convention hours because I had that many. Donna told me they were just going to go poof anyway, so I didn't even bother to submit them. But personally, I think more is better. I take things that I want to know about and that help me with my profession, and I would end up taking them regardless. Some people, not so much. So I think some people need the motivation.
Bart Craddy. I was going to say I'm in agreement with the 15 because you've liberalized a whole lot of other issues like just your participation, active participation in TAPS. That gives you two. So there's 14. Go to a Boy Scout meeting, teach them the survey and merit badge. You picked up another hour or two. So there's your 12 at TAPS or Don Wilson or whoever you want to mention, and you can pick up the other ones other places.
Jimmy Cleveland. I'm a big proponent of the 15 hours. If we're surveyors as a whole, we're struggling for that recognition as a true professional, and I think maintaining that the level of required PDHs, I think it gives us credibility as a professional, and I may get burned at the stake like Stephen said. If we have a surveyor that out there that wants to complain about the number of hours we're required to put in, then they aren't the true professional we're looking for. And as far as the ability to maintain those seminar or those PDH hours in seat time down in the West Tennessee area, we just got the Don Wilson's coming down to do 15 hours down there. We get them from all over the state. So, there's plenty of opportunities for people to get those 15 hours scattered across the state. So, if they don't want to come to whatever convention they decide to come to, then I think those hours are available out there, and it'll be up to them to meet that requirement. I would just hate to see the number of hours required go down strictly because of a trade-off because of the internet service, because we're trying to elevate our profession as opposed to and I understand your position and I respect that, but I think the 15 hours is good for the profession as a whole, in my personal opinion.
Alan or Leonard, have anything to say?
Leonard Tussar, would you consider going to the 4 PDHs of or standards of practice and ethics, like on an every 4 year within 4 years? That would give 2 biennial. It would have to be within a 4 year period, which is 2 renewals. Just
I know I brought the subject up, and it's, I guess, my turn to speak after I hear everybody speak. I'm fine with the 30. Yet I agree with Leonard from the standpoint of the ethics and standards. I think we should make that for every other biennial renewal, which would put it on a 4 year basis. Because, it will be challenging enough for the registrant to go through it that first round, because it's going to be a new thing, and if it's approved this way, we have on our agenda tomorrow to actually discuss how we're going to go about that and how that's going to happen, how it's going to be taught, so forth and so on, because that's part of the criteria that other areas that have that same thing that they have to go through too. So we'll be dealing with that tomorrow if we approve that. But my gut recommendation, after hearing everybody talk, is stay with the 30 hours and take the 4 hours to where it's every other biennial. In other words, every 4-year window, however we need to say that. Now that's where I'm at.
I'm warming up to you there, Tim. I'm warming up to you. let me make this suggestion. Let me make this suggestion to you. I got to get a deal when I buy a car now. Let me make this suggestion.
Okay.
I'm good with the 30 hours, obviously. The PDHs on the ethics and minimum standards of practice. If I understood you right, a registrant could feasibly every 4 years or 2 biennials, every 4 years on December 20th, so to speak, sit down and attend a seminar of some sort and get those 4 PDHs right there. That would be that feasibly could be a 4-year window of no ethics training and no standards training in a 4-year gap. What I've seen in other places has been the same thing but cut in half. In other words, 2 PDHs per biennial, which essentially means a 1-hour course in ethics, a 1-hour course in standards every 2 years. Same number of PDHs over the same period, the 4 years, but it's broken down into now the longest gap I could have in between my ethics training and standards training is a 2-year gap as opposed to the 4-year gap. Does that make sense? That's what I've seen in other states that I've been associated with. I think it seems to work. Personally, myself, never can get too many ethics, never can get too much training and standards. I think a 2-year gap, I think, is a good amount. That's about the amount of time where you start to forget some standards or could use some little update or refresher or maybe something's changed in here, as opposed to a 4-year gap, which is an awfully long time. So what I'm proposing there is same number of PDHs, same amount of time, 4-year window, but rather 2 per biennial.
Okay.
I'm in agreement with that. I was going to suggest that we, if we put it in place and there was going to be 4 hours every 2 years, every hours 1 year and 2 hours the next year, but let's do it this way. I frankly, 4 hours with 2 hours coming every 2-year cycle.
So the only change that would be made in the paragraph as written would be the 4 PDHs would become 2. Is that correct? I know it's a whole lot of discussion to get to that point, Rob, but I think we're happy with it.
Yeah, I think that's right. And I just want to clarify one thing. If I read this correctly, if we were to change that 4 to 2, it would read 2 PDHs shall be earned, completed a course activity, yada, yada, on surveying ethics and standards of practice. What that would mean is, of those 2 PDHs that they have to gain, 1 would be in ethics, 1 would be in standards of practice. Is that correct? Because it says and.
Yes.
That's the way I see it.
Is that the way you understand?
Yes.
In other words, they couldn't do two PDHs of ethics this year and then
No.
2. Okay, I just want to make sure
It
that's clear.
should be one in each.
One of each. Okay.
Do more sense. Alan Crawford, 30 hours, 24 hours. I don't know that it matters. You're looking for quality education. Ethics, good. In the words of Max Billingsley, standards, potty training.
For the record.
For the record, that's it. Good.
Okay. All right, let's move on to page 4 here.
We agree to change that to 2.
Yes, sir.
Okay, next page. Is there anything else in paragraph 1?
Okay, I guess number 3, Rob's where you wanted to add webinar.
Yeah, presenting or attending qualifying seminars and then insert webinars after that. I don't assume that's a generic term and webinar.
On item 6, that was the one that I think Mr. Ward asked about, that I'd like to add a little bit of language to.
That extra sentence.
Yeah, that extra sentence. Item 6, if we could add that extra sentence, Rob, I've got parenthesis, limited to 2 PDHs per organization, in closed parenthesis. It would say requires that a registrant, or the registrant, whichever the words is best, serve as an officer and or actively participate in a committee of the organization.
Actively participate in a committee of the organization.
Yes, sir.
Okay. Now going back up to number 3, online courses are now absent.
Correct.
Is there any, aside from webinars, is there any provision that you would want to use to bookmark any kind of online education, just for so we can come back to it in the future and accept?
I really feel like that addressing in the conversion units, addressing a college semester or college quarter hour addresses that, because if you get semester hours and it happens to be distance learning and it's by the computer, that would be qualify one and the same.
I agree with that. But is there any other language that you want to use to address any kind of other online education? Yeah, I agree that if a college offers it online, then that's...
I mean, it shows up on your transcript exactly the same. I mean, you know.
They definitely have ways of tracking it.
Right. I don't have anything right on top of my mind about that, Rob.
There's a departmental concern. If you want to...
It's my opinion that that would be inconsistent with the commissioner's recommendation on on continuing education being allowed online. Given that many of the professions, there's been an overall trend in graying of the profession, and the younger professionals that are coming in have a different mindset with regards to taking courses online. I think that this would limit to a certain degree commerce opportunities and be inconsistent with the trends that we see in education. I certainly think that requiring the course content as well as the delivery mechanism be monitored in approving an online course, where you couldn't just key through it, go to the end, and where many online courses are very good online courses where you have knowledge-based quizzes through each chapter, and if you don't know the answer to those quizzes, you won't get to the end of the course. Some of the online courses I've taken as a professional are, in fact, excellent learning opportunities because it has a mandate that you pay attention, whereas if you don't know the answer to the question, you aren't going to go anywhere. Certainly in some continuing education courses, you can just show up, sit in the back of the room, read the newspaper, and you've got your hours. I think there is a recognized quality to online courses, but of course it's a professional decision, and however you guys vote to approve it, that's what will be enforced. But I do think it's inconsistent with the trends we're seeing in education.
I would like to point back to what Mr. Crawford so eloquently said earlier, is that the interaction and the camaraderie and the communications that are done interpersonally in a seat time scenario, wherever that scenario may be, is of a greater value to this yet to be grade society that are young guns with these computers than they're able to realize at the moment that they get it. Now, that would be my opinion, and I certainly understand where you're coming from, but I feel very comfortable with what we've crafted here. Okay, I guess, Mr. Hernan, are we down to .04 now?
Okay, if there's no other comments on paragraph 2 or 3, then we are on to rule number 4, which is our conversion table.
Item D, you wanted to add the webinar.
Yeah, because that's pervasive these days. Okay.
I don't have anything else in that section. So you're...
No, sir.
Okay.
Go to .05.
Number 5 is types of acceptable continuing education.
Number 3, after the word seminar, we would also need to add the word webinar to be consistent.
I think paragraph 1 has it too. Seminars. Paragraph 3. Of course, the old catch-all, paragraph 4, all activities are subject to approval by the board.
That really goes back to the comment you were making, Mr. Cleveland, about the out-of-state hours and so forth. The board does have that discretion already, but we're going to incorporate some language for that.
Item 3, did you all catch that webinar would need to be inserted there in 2 places? It's in the first line and in the last line.
Oh, yes, sir. Thank you.
Thank you.
Thank you, Mr. Ward.
Paragraph 6, inactive and retired registrants. Pretty much what we did with this rule is insert retired instead of just inactive.
The question I had on that, Rob, was in paragraph 2. It says that an inactive or retired registrant will be permitted to retain the registrant's original certificate of registration by paying the fee for registration. So we're going to ask the retired person to pay that full fee. Is that the way that reads in? I knew the inactive. Well, the inactive actually is paying the fee. That's the real question that I have. In order to be inactive, you still pay your fee. You just don't do your PDHs.
Well, we haven't changed anything in the rule other than add retired. So payment of the full, however the fee schedule is, hasn't changed. So I guess Donna could answer that. How do they active from inactive?
Inactive, from inactive, they have to submit a written request that they want to go back active,
With their PDHs.
pay $25 and do up to 30 hours of PDHs.
Or take the state-specific
Yeah,
exam
or
again?
take the state specific.
If it's been- if they-
Nobody does that.
Well,
Crazy.
we've never asked an inactive one to, because they're still paying their dues. They're still paying the $140 per year. I think this is contradictory to what the next section says when I read it, unless I'm reading it wrong. It says, I'm going to leave out retired for just a second. An inactive registrant will be permitted to retain the registrant's original certificate of registration by paying the fee for registration without submitting proof. Okay. But the retired registrant does not pay the fee for registration. The retired registrant pays the retired fee, which is a different fee. Yeah, it's a different fee. We're talking about two separate fees here, but we're speaking to them in the same breath, if I understand what I'm reading.
Well, fee for registration is two separate fees for inactive and retired.
I mean, if you feel like there's enough clarity there, that's fine.
Well, it says paying the fee, so it would apply to whichever one you are, because it doesn't say pay the inactive or retired. It just says pay the fee.
It's clear. It's there.
So we don't need to eliminate full registration? Okay.
I don't think
I'm
so.
good with it. If you're good with it, you're the attorney.
Thanks for your indulgence.
Is this yours?
Rule number 7. I think we're rule 7 now.
Yes, sir.
Sir, I think there's a typo there in paragraph 1, inactive registration of 1 year. It says of, or it should be or more. That being a typo.
Or, shouldn't it?
Yep.
Thank you very much.
And the rule's pretty much intact. We've just added retired.
Good with 7.
I'm good.
Yeah, I'm just going back over what Mr. Tussar said here. Or, of, or, I'm reading an inactive or retired registrant seeking to reinstate an inactive registration of 1 year or more. Of 1 year, or should it say or 1 year?
No, right now it says registration of 1 year of more. It should say 1 year or.
I'm sorry, I got the wrong of.
Yeah, you're one off.
However, maybe we need to say reinstate an inactive or retired registration.
Or retired registration of 1 year. Okay, let's stick that in. I will agree with that. All right, I'm good with it.
No further proposed amendments. Rule number 8, noncompliance, remains essentially the same as it ever was, only we have added retired status to it. I was explaining why we're putting retired in, because it wasn't there before, and it was sort of an economic thing, because in the past few years some people have retired with the intention of remaining retired and have decided maybe it's not quite time yet, but there was no provision to reactivate their license. It's just they retired it and they would have to reapply, and that's the reason all this is we're doing this. There was a provision for inactive but not retired. Pretty much a lot of these rules here, that's the only change that we've made.
I think we agreed 8 was okay?
Yes, sir.
Okay, so we're on to 9, hardships.
Number 9, when we originally talked about subparagraph C, the intention was to say something to the effect that this exemption does not waive the requirement, which is now 2 PDHs focused on surveying ethics and standards of practice, even though they were beyond 65. We wanted to make sure that they still kept up with the standards. That seems to be the most common comment I get from younger surveyors, is if you do let the old guys off the hook, they still need to know what's going on. So I'd really like to add something to that nature, if that's okay with everybody. What I said on that, Rob, was this exemption does not waive the requirement of 2 PDHs focused on surveying ethics and standard of practice. So
Paragraph C.
Yeah, on paragraph C.
Registrants under this exemption still obtain H's relative to surveying ethics Divided by 0820 dash. Registrants under this exemption must still obtain the 2 PDHs relative to surveying ethics and standards of practice as provided by Rule 0820-05-.031. Rule number 10.
The only question I've got about rule number 10 is on paragraph 1. Should we include a deadline? Would that be fair to say? Because it just says registrants shall report on a form provided by the board the continuing education activities undertaken during the preceding year. It don't say when. So, how long do they have to do that? Because all of our other rules and regulations require that, for example, we're renewing at the end of December 31st this year, we have to have money and PDH forms in.
Do you think they should have them in? Otherwise, we'll all just compile it in at the same time.
Well, I think what this one is for the odd year, basically. So, do we just want them to just dribble in whenever they decide to send them, or should they be in, by, January 31st, following the preceding year?
That's possible. I guess some registrants won't have any activity in a year.
That's true.
But it says that they still have to turn in a form, though.
Right.
That would
Guess
show.
they would have 0.
That would show 0.
Yeah.
Yeah, absolutely. I agree. There should be a timetable associated with it.
I don't think we're asking them to put anything on it. But they should send the form in every year. But they need to have it in by sometime.
Yeah, not to be nitpicky here, but the way it reads is each registrant shall report on the form, whatever, the continuing education activities undertaken during the preceding year. If they didn't take any during the preceding year, then they don't have to submit it. That's the way it's
activity
said.
would be
Now, I'm
none.
nitpicking.
Yeah, no,
I understand the
that'd be
intent,
true.
but
Yeah, that'd be true.
I think maybe I don't know, regardless of amount of activity or something, obviously there's a better way to formulate what I'm trying to say there, but
No, the activity would be none.
but if I didn't take any, then I don't have to report it. Because it only says I have to report the ones that I did take.
I guess it depends on
Being
which
nitpicky.
which eye you look at it with.
Thing.
If
What
it's-
is.
Do you report nothing, or do you just allow nothing to speak for itself?
Mr. Ward?
Yes, Stephen Ward. Looking back at 820-4-.03, Section 1, where it states that you have to have 30 PDHs per biennial renewal period, I know that in the local chapters when we went through this, to a man, every single person read that to believe that they were only going to be turning in their PDHs at renewal time, that we were going to that we were getting rid of the need to send that form in on the off years, reducing the load on the staff. Now, one thing we discussed amongst ourselves were you all going to then stagger the licensees so that A through M renew this year and the other half in the next year, to break down the workload on you all so that you don't get that crash of all those PDHs all at one time and all of those license renewals all in one single year. That's what we came up with locally, for what it's worth.
May I address? The, I think with switching the other part to biannual instead of an annual requirement, I think this too should be the biannual. We have 4 staff that work on the Land Surveyor Board, and we are going to a more online automated system in the next, hopefully, 12 to 18 months. So applicants, students, licensees will be able to renew online, submit their information, upload to their continuing education, and then it's an audit check for staff to go in and go, okay, they met the requirements. Yes, we will get expectedly some stragglers who wait till the last minute, but that already occurs. So
But would it be your suggestion, instead of saying during the preceding year, during the biennial period?
yes.
Preceding renewal period.
I think that I think the requirement should be, as the licensee is expected after reading the first part of it, everything tied to the biannual renewal. If you don't submit your education and payment, you aren't going to renew. That's all, as simple as that is. If it isn't in sufficient time for staff to process, your credential will expire. I think every professional has that expectation. If I don't do it at least a couple of days before I expire, it might not get processed in time.
I think that's great. I don't have any problem. Anybody got a problem with that?
No.
Okay, Mr. Herndon, if you wouldn't mind, I think we need to take about a 10-minute break, please. If we could adjourn and then reconvene.
Well, should I just change year to preceding renewal period? Then we can move on to the next rule when we get back.
However you want to say it.
Renewal period, I think. Okay, now we can break.
Okay, we'll stop and we'll be at actually rule number 11 we need to discuss.
The hearing's adjourned for 10 minutes.
About 10 minutes, yep. We're going to take a little break.
Hey, Rob, rule number 11's not on my copy. Is that why we need to discuss it?
Shouldn't have been